Yeah, that's all. Absolutely, I appreciate it.
You know.
He's AJ.
Can we pull up the car?
I need you. Can you look this case up?
He's not coming
He doesn't have it on for.
Okay, he did. He definitely forgot about her Monday, so she stepped in and was like,
Get out of jail.
I'm here too.
Good stuff. Yeah.
Hey, these are cases that, the ones that I put DS, those are yours that don't have information files.
Yeah, I filed a shit ton of them yesterday on this, so.
It normally takes a little bit to,
I was ready. I was like ready to flip to you.
do you feel any type of way about it? Because they were just asking me what an offer should be.
I think you're fine. It's fine.
This is a felony VOP.
Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching the miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, people are entitled to a bond absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation, and you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
And telephone number. So as long as you put that in the order, then your motion's granted.
Yes, sir. I'll send that order over to you.
Thanks, Mr. Matt.
Thank you, Judge.
Mr. Rare. I don't see Mr. Rare. Mr. Cotton. Hey, Mr. Cotton.
Good morning, Your Honor.
Good morning, sir.
Your Honor, I have two cases on this morning's docket with you. The first one is going to be Michael Porter. Your Honor, that's a violation of probation. I've met with the state on that. I've given an update. My client is continuing to complete terms and conditions of his original supervision. He's currently finalizing, well, I'm going to say finalizing. He has been evaluated for his substance abuse, and he has started his treatment. Based on my discussions with the state, I think we'd like to have a continuance. I don't know how. I'm going to ask for one. He's got to get through that. I want to make sure he gets through that, and then we will probably be able to resolve this case. I know it's getting a little bit older for VOP, but my client's been diligent in working to complete things throughout that time period.
Okay. Any objection from the state?
No objection from the state, Your Honor. We do want to give the defendant time. If he completes the original terms of probation, I think our offer on how we would resolve it would be a lot better for him, so.
Sounds good. Thank you. Mr. Porter's case is continued until January 8th at 9 o'clock.
All right. Your Honor, the next case I have is Juan Salazar. Your Honor, Mr. Salazar is incarcerated. I met with him yesterday. Is he put? Huh?
He should be.
Mr. Salazar is present.
Yes. For those of you in the gallery, if you have phones, I smile because Don Durrell, a defense attorney who's now retired, talked about appearing in federal court, and his phone went off, and he said, the judge put my phone in jail. So it took their phone for a period of time. In order to prevent your phone from being put in jail, please make sure it's turned off or you have it on vibrate. Thank you. Okay.
Good morning, Your Honor. For the record, Byron Cotton, Mr. Salazar is present before the court. Your Honor, I met with Mr. Salazar yesterday, updated him on his case. I got on this case recently. It has been going on, I think, for one cycle, but I just got on it probably 2 weeks ago. Your Honor, I'm requesting a continuance. Mr. Salazar understands he's incarcerated, I think, because of the type of charge. He's not eligible for bond, but I'm going to request a continuance to see if I can resolve this case and/or speak with witnesses. I do not want to set it on the evidentiary on this cycle, but because he's not eligible for bond, I would want to on the next cycle if we're unable to resolve.
Okay. So, and I made a mistake on Mr. Porter, and we'll come back to that, but I
Okay.
put him on a pretrial docket, which it's not a new case, right?
These are both probation violations, yes, sir.
Exactly. So how far out do you want me to set Mr. Salazar's case?
What do you have, about a month-ish, 4 weeks-ish? I don't know how the
I've
court's...
got January 11th and January 18th.
Earlier, probably. January 11th, Judge, that way we can get back for the court with an update.
Okay. So, Mr. Salazar, I'll see you on no later than January 11th at 9 o'clock. If Mr. Cotton wants to set a hearing before that date, then I'll see you then. Okay? Thank you, sir.
Thank you.
Now,
All right,
let's
we need to
go
go back to Mr. Porter.
Let's go back to Porter.
Yes, sir.
Don't want to set him on a pretrial. Do we want to set Mr. Porter for January 11th or 18th? I don't know why.
Judge, I would say the 11th just for the sooner, since I'm going to be here anyway.
Okay. January 11th for Mr. Porter, 21 CF 1835.
Okay. Your Honor, I believe that's all I have on your docket this morning. Thank you.
Thank
And
you,
I'm
Mr.
not covering for anybody, so I don't forget to cover them today. Thanks.
Thanks, Mr. Gunn. Mr. Rare, come on up. Morning, sir.
Judge, the first I have this morning is Mr. Eric Mountain, and Mr. Mountain is present and approaching, Your Honor, and we have a VIP plea if I can approach.
Yes, sir. I'm sorry. Yes, sir. Gotcha. Thank you. Good. Mr. Mountain, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. Mr. Mountain, did you read the plea agreement?
I did, yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
I did, yes.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Extremely.
Did you sign the plea agreement?
I did, yes, sir.
Mr. Mountain, I do accept your plea. Have you ever been adjudicated guilty of a felony before?
He has not, Judge. It's a misdemeanor DUI is the only condition left on probation.
Good, excellent, okay? Even better, Mr. Mountain. So you're adjudicated guilty of the misdemeanor, your current supervision is revoked and terminated, you're sentenced to credit for time served, you'll need to pay the $100 VOP fee, and you're
Yeah,
privately,
I may have written that wrong. I think I wrote a $50 VOP fee, Judge. It should be $100, so
Right.
you're fine with the additional $50 on that. Thank you, Judge.
$50 on what?
You're correct, Judge. It's a $100 VOP fee. I wrote 50 on the plea form.
Right.
I understand it's actually 100.
Yes, sir.
Right, and there's no $150 cost of prosecution. There's just the one $100 fee. All outstanding requirements are D6'd. All outstanding, you don't want any time to pay off any financials, Mr. Mountain? Mr. Mayor?
Judge, if he can have 90 days, he may be able to pay out some or all of that, and then
Okay.
collections thereafter.
So, Mr. Mountain, if you fail to pay all of your financials within 90 days from today, then they will go to a civil lien or judgment, okay?
Yes, sir.
Thank you, sir. Good luck to you.
Thank you.
Yes, sir.
Next, Your Honor, I have on the docket is Mr. Joseph Rogers, 22 CF 2515. Mr. Rogers is present and approaching. And, Your Honor, we're here before the court on a motion to modify bond.
I sent you that.
Briefly, in summary of the motion, Mr. Rogers is before the court for felony DUI. As a condition of his original bond granted by this court, his conditions included no alcohol, random urinalysis, breath testing, and a scram monitor. That was imposed in late September 2022. To date, he has had 0 violations of pretrial supervision, 0 instances of alcohol consumption. I think this is something we may have raised with the court on the previous court date as well, but Mr. Rogers has been going through some medical procedures.
Yes, sir.
There is a possible cancerous, I think nodule is the phrase that was used, in one of his lungs. He's got a procedure coming up December 4th. I'll ask him a couple questions in a moment, but the concern is the possibility of removing scram before he has that procedure on the 4th, and then he's got a biopsy follow-up following that. If I could place him under oath, Judge.
Mr. Rogers, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir.
Mr. Rogers, can you give the court a brief summary, just leading up to the present day of the lung issue you're having?
Well, I've had a CT scan, a PET scan, CT scan. When I had it, they showed that it several nodules in the lungs, which could be part of my breathing and the weight loss that I had, along with everything else with my COPD I got going on. Then they did a PET scan, and it showed that it had doubled in size since in 2 months. So here we go with need to have surgery done on that to check the lymph nodes, the nodules. They've also found that there's several other nodules in my other lung that have shown up since then. You know, it's just a little overwhelming. So that they're going to do an electromagnetic robot.
Yes, sir. Okay, let me stop you, Mr. Rogers. You don't need to go any further on your medical condition. As far as what are they planning on doing? Their lung surgery on December 4th?
Yes, sir.
How long do you think you'll be in there?
Well, the procedure's going to be a day.
Okay.
And then when I got to follow up a week later to see whether they're going to need to go back in and do anything else.
Okay, let me stop you again. Mr. Rare, when I was doing my homework, here was my note to myself. And subject to this state telling me what their thoughts are, but when I was doing my homework, I put grant, but only for the time needed by MD's probation to monitor, ? So those are my thoughts coming on the bench. If I let probation determine when the monitor needs to be off and on because of the procedure, I know you're asking for it to totally be removed. The state may not have any objection to that at all. But because it's the 4th DUI, they may. So let me ask the state, what are you seeking?
Okay, so it's the 6th DUI, Your Honor, not the
Okay.
4th. So I do sympathize with Mr. Rogers. I agree with the court in that, first, I haven't received any kind of medical documentation that there's any kind of procedure or that the monitor on his ankle would even interfere with that. So I would think it'd be appropriate if a doctor provided something saying we would need this monitor removed in order to do this procedure, then I think that would be fine if the court allowed it to be removed. But I would want it to be promptly reinstalled after the procedure was completed. But to this date, I haven't had any medical documentation that he suffers from anything. So I would like to see that and have something from the physician stating that a monitor on his ankle would interfere with the surgery on his lungs.
I understand.
So-
Does Mr. Rogers have a driver's license at this point?
He does not.
Okay. Probation, is that something that y'all could,
Your Honor,
Could monitor-
he's not under state probation.
Right, pretrial. Judge, something, if that's what the court's inclined to do, just to put strict parameters on the court's requirements, if it were to be, it's removed for like a set period of time. So the thought process I'm thinking of, if the procedure's on December 4th, the week of the 11th, I don't think they've set a specific biopsy date yet, but it's supposed to be the week of the 11th, the following week. If the court says Scram may be removed as a condition of pretrial until, I'll throw out a date, Monday, December 18th, at which time it must be reinstalled on that date unless further or the court extends it. That way there's a preset cutoff where you have to have it back on. And again, unless there's some medical issue where we have to come back before the court for a renewed motion.
okay, so the start date to remove would be December 3rd?
Whatever the court would require on that, just any time before the surgery.
And then place it back on when?
My suggestion would be December 18th, Monday. That would be the first Monday following the week where his biopsy follow will be scheduled following the surgery.
Okay. So the motion is, one, I want to see, I'm like the state, I want to see something in writing from an MD that says that he needs to have that removed before he can have that procedure. And if I receive that, then the motion will be granted to have it removed on December 3rd, placed back on December 18th. But the condition precedent is I need to see something from an MD that says it needs to be removed at all.
I can go right down the road. I can go get that.
Okay, get it to Mr. Rare, and he'll get it to the court and the state. Okay?
Thank you, Your Honor, and I believe that's all I have this morning.
Thank you, Mr. Rare. Thank you, sir. Good luck to you.
Would you like me to notate those dates on the sheet or just put order to follow?
I would just wait. Mr. Flaherty. Morning, Mr. Flaherty.
Good morning, Your Honor. Tim Flaherty on behalf of Guy Nelson. Mr. Nelson is an inmate.
Thank you, ma'am. Morning, Mr. Nelson. So, Mr. Flaherty, I read your motion. Here are the highlights of it that literally I highlighted, was that what the charges were. Defendant was given a bond of $500,000 cash or professional first appearance. Again, the facts of the case, who the alleged victim was. The defendant's wife has secured an apartment in Crestview, and your client has no prior criminal history. I also did read through the affidavit of the defendant's son, the father of the alleged victim, correct?
Yes, Your Honor.
Okay, I read through that and made some highlights on that.
Yes, Your Honor. And Judge, again, not to reiterate everything that was in the motion, the difficulty with a case like this is we all have to acknowledge the seriousness of the allegation, but also be mindful of the fact that these are allegations at this point, and he has not been proven guilty of anything. Up until this arrest, Mr. Nelson has never been arrested. He has no prior criminal history. He served 22 years in the United States Air Force, retired honorably. He served as a civilian contractor until last year. And what makes this case difficult from a bond standpoint, Judge, is that last year when they retired, they bought an RV with the intention of traveling to see their children and grandchildren. So he doesn't have a home, which would normally be used to secure a bond. So whatever amount that the court sets this morning is probably going to have to be posted in cash. So we're asking the court to consider a $100,000 cash or professional bond. We think that that is still a sufficient monetary amount to allow Mr. Nelson to, quote, have some skin in the game. We think that there is nothing in his background to suggest that he's a flight risk. He has always honored his commitments, both serving in the military, serving as a civilian, taking care of his family. There is nothing to suggest that he won't take this serious and meet those commitments. We also do feel, Judge, that there are conditions that the court can impose that will ensure his appearance in court and protect the community from any concerns that the court might have. The court could order community control sanctions, put him on a monitor. I would also point out that his wife, Ms. Nelson, is present in court this morning. She had submitted an affidavit to the court along with our bond motion, but she has secured an apartment in the Crestview area just so that he does have a local address. She has indicated that she is willing to stay in the Crestview area until this case is finished, to ensure that not only does he show up for court, but also that he stays inside, that he stays at home, and abides by the court's community control sanction order if that were to be ordered. So on that basis, Judge, we would ask the court to consider lowering the bond from $500,000 to $100,000.
Thank you, sir. To the state?
Judge, we absolutely believe the bond is appropriate as set. It's a very serious case involving a live 4-year-old victim. Obviously, it's a capital felony, so he is facing life in prison. There are very serious allegations that he penetrated a 4-year-old child, her anus as well as her vagina with his fingers and mouth. Victim's father said he had access and corroborated that he would stay in that bedroom. There was an immediate disclosure when he woke up that morning, and when he was being taken to security forces, he began shaking and vomiting. Child victim gave a very clear disclosure at the CAC, and victim's father's own statement says she never wavered when he was going over it with her. Medical exam found abrasions and bruising near the vaginal opening and hymen, and she reported pain urinating. She also came back to the CAC several days later with her mother, where it was determined that she had a herpes outbreak on her genitals that was believed to be a primary HSV infection. Male DNA was located on the swabs taken from her external vaginal and her anal swabs as well, and those results are pending. Under considerations for the court regarding bail, it should take into account the weight of the evidence against the defendant. In this case, there was the clear immediate disclosure from the child. Access to the child during the time frame is corroborated by her own statement as well as her parents. The medical findings with bruising and abrasion in her private areas. The presence of male DNA with results pending in the external vaginal and anal swabs. And the child victim now has an STD with a likely primary outbreak when this incident occurred. So state would submit this is a strong case. We would also like the court to consider the defendant's ties to the community. He's absolutely a flight risk. He did live in an RV for a long time. He was down here visiting and doesn't have any ties to this community. I understand his wife has obtained an apartment in Crestview, but that's obviously very recently as a result of this particular case.
And we don't dispute that, Your Honor. We're not
sorry?
disputing that.
Right.
So we have the same flight risk concerns we would have had they been staying in the RV, given it's a brand-new residence. And I understand there has been a sworn affidavit from the defendant's son that was filed by defense and attached to their motion. And frankly, we have concerns with that statement as well, that he might have access to that child if released, given the alignment of the victim's father. Essentially, we believe the bonds are absolutely appropriate as set. We would ask the court to consider, in addition, the forfeiture of passport, in addition to all the intensive pretrial conditions, including GPS, no contact with minors whatsoever, no contact with the victim, and intensive weekly in-person pretrial reporting as ordered by Judge Schlechter at first appearances.
Okay. Mr. Nelson, as I was doing my homework, I see the charges. I read the arrest report, and my knee-jerk reaction is, I'm not going to modify this bond. But then your son's affidavit, his statement carries a lot of weight with the court. If it wasn't for his statement, this would have been probably a shorter hearing, or at least it wouldn't be as difficult a decision for the court. Based on all the evidence that I have, which are the affidavits, your motion to reduce bond is granted, your bond is reduced, and so it's modified, so all the other terms will be the same other than it's reduced to $100,000 cash or professional. You will have community control sanctions. You'll need to wear a GPS monitor. And again, all the other conditions of the original bond are continue in place. Mr. Flaherty, by saying that, anything conflicting or anything else the court needs to address?
Not that I can think of offhand, Judge. We'll certainly prepare an order that contains all of those announced conditions from the court, and we'll also incorporate the original conditions that were imposed at pretrial service, or at first appearance,
Good.
that remain in force.
Okay. When will I see Mr. Nelson next?
We are set in, I have it right here,
Is
Judge.
it January 8th?
We have January 8th pretrial, Your Honor.
I'll see you January 8th at 9 o'clock.
Thank you, Your Honor.
And Your Honor, would that include forfeiture of the passport to pretrial services.
Yes, ma'am, I do that. Thank you. Thank you, ma'am.
Thank you, Your Honor.
Thank you, sir. Ms. Merrifield.
Good morning, Your Honor.
Good morning, ma'am.
Brenda
Need to be
Merrifield on
careful
behalf-
about putting both names on one line because I may skip it, so.
I was trying to provide ease to the court as they are both found under Mr. Flaherty's name. I'm here on behalf of Mr. Nolasco Benitez and 23 CF 880.
Yes, ma'am.
And we're here on our motion to withdraw as attorney for record. As the court may recall, on November the 13th, we did address this issue. Some information was brought to light about Mr. Nolasco Benitez. I have not had any contact with him. I have been unable to have a meaningful conversation with him. And there is an allegation that he has absconded from pretrial supervision.
Okay.
So at this juncture, we would be asking to be removed as attorney of record, as we're unable to represent him if we can't have any communication with him.
Is there an outstanding case or anything for
No,
him?
Your Honor.
So, Mr. Benitez wasn't put on notice of this hearing, but he didn't, you filed a waiver for the last hearing?
So there was a waiver that was on file because this case has been going on for quite some time with pretrials and docket days. And what I represented to the court on the 13th was it wasn't appropriate to hear this motion on the 13th because we needed to make sure he had the opportunity to be heard. I did send the notice of our motion to withdraw and notice of hearing to his last known address. It is an address that I know that his family resides at, so I know they have received the notice, but have had no contact with him. So unfortunately, that is the only address I have for him, and I did not see him in the audience today, Judge.
A capias is entered for Mr. Benitez. The motion to withdraw is granted. Similar to the other order that you may have heard this morning, make sure that it has the last known physical address, email address, and telephone number in the proposed order.
Yes, sir, Your Honor. I do have one prepared. However, I want to verify the email address, so I'm going to submit it through the e-portal this afternoon.
Okay, thank you, ma'am.
Thank you, Judge. I believe that's all I have.
The bond is no bond. Thank you. Mr. Patel. Hello, Mr. Patel.
Good morning, Judge.
Good morning, sir.
Jay Patel and Tim Shaw on behalf of Brett Stephen Bay, 21 CF 653, 21 CF 1136. We are back before the court on Mr. Bay's case regarding this witness that doesn't want to appear. As the court had the benefit of reading the motion, I made it as detailed as I possibly could.
Yes, sir, thank you. Regarding Mr. Matthews.
Yes.
Correct.
At this time, we're asking for, we're moving the court for an order to show cause for Mr. Matthews to come before the court and explain how he has the wherewithal to leave the county, go to Fairhope with 2 broken ankles, and then call us and tell us that he's not coming to this deposition that we had served him.
And also, did the time periods for him being in Twin Cities Hospital, did that didn't overlap with the time that he was supposed to be there for the deposition? Correct?
No, Judge, it appears that he was admitted on October 5, 23, and discharged on October 9, 23, and the deposition was October 17, 23.
Thank you. To the state?
Judge, I know Mr. Patel was not present for the deposition time that we had set aside for Mr. Matthews. So he may not have understood everything that happened because Mr. Shaw and I discussed this quite a bit and actually even started discussion of going to Fairhope to depose Mr. Matthews. So what I explained to, and Mr. Matthews is present on Zoom whenever we want to ask him anything.
Excellent.
So Mr. Matthews, my understanding, there was concern from the defense's side because there was a delay until like the day before that there was now discussion about Mr. Matthews being in Fairhope. And I had explained to Mr. Shaw that that was on us of the delay. So Mr. Matthews had been calling my investigator to let us know that he had been hospitalized and had been released. The only place that he had any help to take care of him, because at that point he was bedridden with 2 broken ankles and 2 broken heels from falling off of a roof. So he had to go to Fairhope, where he had family to take care of him. So he started calling, and my investigator was off on that Friday. So I didn't get the messages until Monday, and the deposition was supposed to be on Tuesday. So we reached out to him, and I guess Mr. Matthews had apparently also contacted Mr. Patel's office as well. And so we discussed it with him, and he said, look, I'll appear by Zoom, that's fine. It's just the ride to get back, because he was pending surgery. My understanding, I think he had this surgery Monday or Tuesday of this week.
Do you want to put him under oath and ask him some questions?
I was just not sure how he could hear, so that's why I was trying to explain what my knowledge was of the situation.
Mr. Matthews, can you hear us okay?
I can hear.
Good, okay. Thank you.
Mr. Matthews,
Mr. Matthews, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down.
Mr. Matthews, all of the information that I've explained to this point, does that all sound accurate?
Yes, ma'am.
So he supplied us with medical records also, showing his hospitalization for multiple days. So then there was surgery. My understanding, it was at the beginning of this week. Is that correct, Mr. Matthews?
Yes, ma'am.
To actually do the full repair on his legs. So that was the reason for his non-appearance. He offered to appear by Zoom. He just trying to make that physical trip over was the problem. So.
Okay. Mr. Patel, finally, what do you want the court to do?
I'm asking for an order to show cause.
Okay,
Judge,
well,
this
we're
is
going to
a-
end up right back here doing what we're doing now.
But the problem is, Judge, we've been spinning around circles. I've been trying to subpoena him since March of 2022. Everything has been done on this case. This is a homicide case. I think it goes without saying that all the Zoom rules that the Supreme Court's putting into place contemplates the fact that it doesn't allow Zoom for evidentiary hearings. I surely, and my client does not think that depoting him via Zoom is the appropriate thing to do in this case, given the nature and circumstances.
I understand, but if Mr. Matthews now resides out of the state, don't you have to go to him?
Well, I don't know if he does. He could just be staying there. The problem that I'm having is the ball keeps moving,
Okay,
and I've only got certain tools.
Why don't you ask Mr. Matthews whatever questions you have regarding residence or anything else, or the court will.
Okay. Mr. Matthews, well, state your name for the record. Is he under oath, Judge?
He is.
Jason Matthews.
What kind of driver's license do you have?
I do not drive, and I'm unable to drive. I'm bedridden still, but I do have, at this time, I'm stable enough, and so I just had surgeries, that I could get transport to Okaloosa County.
Okay. Can you just answer the question I asked? What kind of driver's license do you have? A Florida driver's license or an Alabama driver's license?
No, I don't have a license.
Okay. Do you have an identification card?
Yes, I do.
Okay. Is that from the state? Is that issued from the state of Florida or the state of Alabama? Okay. Judge, it appears to me he avails himself to the state of Florida. He just said that he can arrange to get transportation here.
Okay. When do you want to depose him?
Here's what
It sounds like that the state is the one that has backups on deposition time. When's the soonest that you could make time for Mr. Matthews to be deposed?
1 second, Judge. I've got deposition dates set out through December and January and February already set on my calendar, so.
And there's no time you can make
December
them.
1st, Judge, would be the first date.
Sorry, December 1st?
Yes, Judge.
Okay.
Or I can do December 5th or December 7th.
Okay, thank you. Mr. Patel, which of those dates do you want to do?
December 1st.
Okay, at what time?
I don't see anything else scheduled yet on that December 1st date, Judge.
So 9 o'clock, or do you want it later? Mr. Matthews, are you going to be driving over that day, or are you going to come the day before?
December 1st at 9 a.m.?
Well,
That morning.
and unless it's going to take you longer to drive over here, do you want to, and I don't know how long the deposition's going to take. Mr. Patel, how long do you think it'll take?
Hour max.
Okay. What about at 10 o'clock on December 1st? And where will that be, Mr. Patel?
At the state attorney's office.
Okay, at the state attorney's office, 10 o'clock a.m., December 1st. And
Okay.
Mr. Matthews, if you fail to appear then, and I get an affidavit from Mr. Patel that says that you didn't appear, then I'm going to issue a capias, basically, where they'll come arrest you, and then you'll come before the court for a hearing, and there may be a delay for that. So just make sure that you appear December 1st, 10 o'clock, State Attorney's Office.
And Judge, for the purpose of perfecting service, can we issue the subpoena to the state of Florida?
You can certainly do that, but he's ordered by the court to be there
Okay.
at that time, if you want to put that in the order. And he's attending via Zoom, so I don't think you have to serve him in any other manner.
If the court's fine with that, I'm fine with that.
I am.
Judge, I want to make clear, so at this point, the motion for order to show cause is denied?
Correct.
Thank you.
Yes, ma'am. Thank you, Mr. Matthews.
Thank y'all. See you at December.
Yes, sir.
10 a.m. first.
Thank you, Judge. I have nothing further, may be excused.
Yes, sir, thank you.
Judge, I have nothing else this morning. This afternoon, I was scheduled with Mr. Swiatek for a sentencing on Mr. Reagan, but I saw this morning that Your Honor had signed a motion to continue to December 21st.
Okay, good.
If I can be excused for the
Yes, ma'am, thank you. Ms. Jacob,
I graciously am going to allow Mr. Flowers to go before me.
graciously, okay.
Age before beauty.
Ooh, Mr. Flowers,
I'll accept that, Judge.
not that gracious.
Your Honor, good morning.
Good morning, sir.
Okay. Your Honor, I have one motion before the court today. Mr. McCraney, who's incarcerated.
Yes, sir.
See, I wasn't in on this deal
I know.
that happened, so.
And Judge, I appreciate it. I was in Judge Wells' division and heard you as quickly as I could, sir. Judge, this is Mr. McCraney, and he's aware of the motion we have filed. The court may have had
I've
an
done my
opportunity
homework.
to read the motion.
Mr. McCraney, I have. Mr. Flowers is seeking to withdraw. He states irreconcilable differences. I don't know what those are, but do you object to Mr. Flowers?
No, sir.
Okay. So the motion to withdraw is granted.
Judge, should I submit an order to the court?
If you will, if you, in accordance with the rules of judicial administration, if you'll put last physical address, email address, and telephone number for Mr. McCraney. in
Yes,
that
sir, I'll be
order.
pleased to do so.
Okay. Thank you, sir.
Thank you, Your Honor.
So, Mr. McCraney, Mr. McCraney, wait a minute,
Wait.
let me still talk to you. You don't have a counsel. Thank you, Mr. Flowers. Do you intend to hire a private attorney, or do you wish for me to appoint the public defender if you qualify financially?
I thought, Mr. Brown, that Mr. Notes would be picking up my other case as well.
Okay, so you're going to hire Mr. Notes?
No, sir. I thought that's what we talked about on Monday.
Appointed on his other case.
Okay. So you want him to represent you on this case?
Yes, sir.
Okay. I do appoint Mr. Nopes to represent you on this case.
Yes, sir.
Yes, ma'am, Ms. Jacob.
Mr. Nose is going to call my office and ask for an order so he can get paid. So could the court go ahead and go through the motions of appointing Mr. Kleins, let Mr. Kleins withdraw, and then let me withdraw so I can provide an order?
Yes, ma'am. I do appoint the public defender to represent Mr. McCraney in 22 CF 2546.
Your Honor, we would ask to withdraw.
Motion is granted. Ms. Jacob, you want
Can
to?
you give me that case number again? Sorry.
It's 22 CF 2546.
Thank you, Your Honor. And Your Honor, my office has a continuing conflict as well, and we would move to withdraw and have Mr. Nopes appointed.
And I don't think I've ever granted so many motions to withdraw in one case in one day. That is granted also, and the court appoints Mr. Nopes.
And may I provide the court with an order later today, Your Honor?
Please, ma'am.
Mr. Brown,
Ms. McCraney, I think that means I'll probably see you on January 8th.
Yes, sir. Have a great one, sir.
Thank you, sir. You too. Yes, ma'am.
Thank you, Your Honor. I have two matters before the court today. The first is Antonio Lee. He is present and approaching. Excuse me, Your Honor. We are here for a bond hearing. First and foremost, I don't believe the state is going to object, but there has been a substantial change in circumstances in this case that I believe substantiate a second bond hearing.
I have to object.
Okay.
Yeah.
The state is objecting, Your Honor. However, given the fact that the officers who were properly subpoenaed did not show up for depositions and the state's next available date is in February, I think that alone substantiates a second bond hearing. However, also the details that I've pointed out in my motion that were not available to me at the time of the first motion because we had not had an opportunity to review the discovery yet.
Okay. To the state?
Your Honor, the state would respectfully request the denial of this bond reduction. We do understand the defense's position, and we don't disagree in the sense that, we do understand that it takes a while for us to schedule these depots. We have been putting as many depot dates as possible. I also acknowledge the issues with their surveillance video that was described in the motion. However, I think there are also other facts that point to the idea that the occurrence and the testimony of the witness, while it may be, it kind of bounces all over the place, there is a huge language barrier with this victim. I think the facts that we see in the report is that this defendant was found with the stolen vehicle at a property in Crestview. The victim testified that he was held at gunpoint, that he was battered. I think if we look at the defendant's criminal history in this criminal history, we see that grand theft auto isn't a one-time occurrence with him. Burglary isn't a one-time occurrence with him. Petty theft isn't a one-time occurrence with him. As a matter of fact, I think he has 13 burglaries, 4 GTAs, 6 petty thefts, 2 grand thefts of a firearm, 1 grand theft, 1 burglary of a dwelling, 2 fleeing and attempting to elude, 1 criminal mischief felony, 1 principal to aggravated assault, one possession of a firearm by a minor, and 1 criminal mischief. It's very clear that this defendant is not amenable to following the law. He was actually sentenced to a prison sentence, got out, and then committed this alleged new law that we're talking about here. I don't think it's a coincidence that we're sitting here talking again about a grand theft auto, a situation where another firearm was involved. I do understand the defense's position that this has been somewhat delayed because of officers not showing up and that there may be some discrepancies in how the event took place, but I think it's very clear from the testimony of the victim and through the police report that was gathered that this victim did get held at gunpoint, that he was battered, and that his car was stolen along with his cell phone. And that given this, we would respectfully request and state to this court that the bonds that have been set are an appropriate bond amount for the charges that have been handed, or for the charges as they've been charged. Therefore, we respectfully request that this court deny the bond reduction and keep the bonds in place as they are.
And I apologize, Your Honor. I think I understood that the state would be objecting to the bond reduction. I don't think the state was objecting to Mr. Lee having a second bond hearing.
Oh, yes. I'm sorry. Yeah, no.
So understanding what Mr. Gomez said, Your Honor, in support of his request for the court to deny it, Your Honor, I understand what the alleged victim has said. However, it is fairly obvious from listening to what the officers are narrating while viewing this surveillance video that it did not happen. The officer says that the victim is leaving on his own, though. Why is he opening his own back door and got in on his own? And then the officers narrate that, I bet they just dropped him off at his house and took his car. There is absolutely, and here's the issue with the officers not showing up, Judge. This video is clearly exculpatory for my client because it proves that certainly no kidnapping or carjacking happened. The problem
Okay,
here.
Let me stop you 1 second. In paragraph 5, you say the video cannot be located by the state.
So at this
You're talking about
time,
another video?
this is the video. The problem is the officer who is wearing her body cam on her chest and she's bent over watching the video like this. So we can see portions of it and then she'll bend back down. So I'm only have what she's narrating. I don't have the actual video itself, which is why the depositions of the officers were so important. Quite frankly, if we had that video, great, we'd be ready for trial because that video completely contradicts what the alleged victim is saying. So I have my own opinions about what actually happened in this case, but I'll reserve those. I think at best
So
the
you
state-
believe that the video that you do not have depicts the alleged beating by the defendant of the victim with a pistol?
The lack thereof, Your Honor. Where the alleged victim alleges that he was carjacked and beaten by the defendant with a pistol in the parking lot of the hotel. The problem with that is there's video, and the video does not show that based on what the officer's narration is in the video. So I believe that I either need the officer to come in and say, yes, I collected that video, and then I need the state to follow up with law enforcement and figure out what happened to it, or the officer to come in and say, no, I didn't collect that video, and then I need to file a motion to dismiss based on a failure to preserve exculpatory evidence. But without the officer's testimony to that about who did what and who did or did not collect anything, then I don't have the basis yet to figure out where we're going, and I can't move this case forward.
I understand.
So I understand that Mr. Lee has prior criminal history. Mr. Lee has been in jail for nearly a year already on this case. He is not going to be able to get his depositions rescheduled until at least the end of February. At that point then, either the state will need to seek out what happened to this video that was collected, or I will need to file a motion and set it for what I anticipate will be a lengthy motion hearing.
Yes.
So we're talking at least past probably April or May of next year. So the reality of the situation is we've got someone who's sitting in jail on a $750,000 cash or professional bond for charges that are very likely not even true. So that is why we are here today, Your Honor, and I am asking the court to reduce the bonds. I'm not asking the court to give him a signature bond and let him walk out of the jail. I'm asking the court to just simply reduce the bond to something that he realistically can get a bondsman and afford to pay a bondsman the 10%. He's willing to cooperate with whatever pretrial services the court wants to put on him. But at this time, I think it's become fairly obvious just from reviewing the body cam that the state provided in this case that the charges are highly unlikely to be substantiated by that evidence.
Okay.
Your Honor, I just want to point out the evidence in question that we're talking about, this surveillance video, it captures a very small moment of time of this entire crime. So while that video may depict something, that doesn't mean the crime didn't occur. It's more about the method with which the crime was carried out. And so I think to characterize the video as outright exculpatory, I don't think the state would necessarily be able to agree with that based on the statements of the victim. And I think that just needs to be understood that it's not clear that this video would be exculpatory. It only shows a very small moment in time of the actual events that occurred.
However, it does 100% depict the exact moment in time the alleged victim said this occurred. So it may be a very small snippet of time, but it is an extremely important snippet, small amount of time.
Understand. Mr. Lee, I'm not aware of any authority that says that because of a delay in depositions caused by the state or the delay by law enforcement officers not being there, the time period for the state to provide deposition time. Your attorney's very passionate. She believes what she's saying. I believe that. I understand her frustration. I'm just not aware of any authority that says, based upon the state arguably dragging their feet for whatever reason or delaying that then the court has an obligation to reduce your bond, or that there's some criteria on how I can reduce the bond. And so it's almost a sanction against the state that's being asked for. Because the state isn't doing this quick enough, I understand Ms. Jakewood's also argument factually, so that's separate than what I'm talking about. Because the state isn't providing this time and those things, therefore, the bond's going to be reduced as a punishment to the state, and that just, those two don't go hand in hand in my mind, because the citizens of the state of Florida is the reason why the court sets bonds. But I do understand her frustration. I do understand her argument as far as the evidence and the strength or lack of strength of the state's evidence, as Ms. Jakewood is stating that to the court. Respectfully, your motion to reduce bond is denied. I will rule on any motion to compel officers to attend. I'll rule on any motions to prevent the state from using videos that aren't produced. I'll rule on any motion that's before me, but I don't believe I can get to where your attorney wants me to get, and the court finds that it will not, on the motion to reduce bond. So will I see Mr. Lee on January 8th?
No, Your Honor, we had to set it for March 11th because the soonest available date was the end of February. And Your Honor, I do want to make clear, I don't think that Mr. Gomez is dragging his feet or not giving me depo time. In fact, I think Mr. Gomez is making every effort to avail himself so that we can set these depots sooner. The reality is, just between his court schedule and my court schedule, it's just not an option.
Right.
Your Honor, my argument here is more geared towards the fact that the bond should comport with the seriousness of the case, and the evidence has shown that the seriousness of the case is different than what the court previously knew.
You talk about evidence. I don't have that in evidence. All I've got is the arrest report that says the defendant entered the vehicle, ordered the victim into the back seat after brandishing a firearm. Victim was beaten. The victim was beaten by the defendant with a pistol. Injuries to his face, bloody and swelling to his lip, lacerations on his left cheek, and bruising of the jaw, swelling below the right eye, large contusion on the right side of the forehead. And then the co-defendant took the victim's cell phone. So that's what I highlighted in the arrest report.
Then I would move to continue the bond hearing, Your Honor, and I'll provide that video to the court.
Okay. To the state, any objection to that?
We have no objection, Your Honor.
Okay. Then the motion to continue the hearing is granted. How far out do you want to set it?
Your Honor, I have the video. I just need to basically just truncate it so the court knows exactly what it's looking for, and so it's not watching 2 hours of video. So I can do that this afternoon, so as soon as the court is available.
Okay, let me ask you this. Do you want to send that to the court, also send it to the state, and then the court just watches that and then decides if I need another hearing?
I think that would be the most expedient, Your Honor, especially with the holidays next week. And I will get with Mr. Gomez and just let him know. All I'm really going to be doing is just cutting off the beginning and end of the video so the court is not watching 2 hours of video to try and find the parts that are pertinent. So I will speak with Mr. Gomez, let him know exactly what I plan to provide to the court, and make sure he doesn't have any objection, and then I will provide that to the court via email with Mr. Gomez's stipulation.
And Your Honor, if the state may request, if after viewing that video, the court feels inclined to change its position on this bond hearing, I think the state just, if in a situation where the bond is lowered, the state is going to request a GPS to be placed on the defendant, and then also we want no contact with the victim and no contact with the co-defendant in this case.
And that's perfectly fine. We have no objection to that, Your Honor. Mr. Lee was given a furlough, if the court recalls, where he was fitted with a GPS. He was released. He went to the funeral. He actually arrived back at the jail, it's my understanding, a few minutes before he even had to be there. There's no allegations that he violated anything or contacted anyone. We have no objections to any of that. Okay. We would just ask that the court order that GPS be at $1 a day, or whatever the minimum cost is nowadays.
Mr. Lee, how much money do you make per month?
My mother is a nurse, and I work up there with her sometimes at the Emerald Coast.
So how much do you think you've averaged making per month over the last 5 months?
$0. He's been in jail, Your Honor.
Okay, that's right. You've been in jail for a year. Okay, thank you.
Apologize, Your Honor. I didn't mean to cut in. But
no, that's a good point. Okay.
I know Mr. Lee was like, I don't know what I'm supposed to say.
Right, okay. Mr. Lee, then basically I'm taking the motion under advisement. I'll watch the video that your attorney provides to the court, and I'll base my ruling after reviewing that, okay?
Okay.
And Your Honor, just for the court's information, he would be residing with his mother, Tasha Claiborne, at 2109 Wilderness Path in Fort Walton Beach, if he's released. So just for the record, I will provide that address so if the court chooses to do CC sanctions or anything of that nature, in addition to a bond reduction, we will make sure that you have the correct address.
Good, okay. Will pretrial monitor CC sanctions?
It is my understanding they will.
Okay.
But I'm not really sure. I don't really know exactly how they monitor it, Your Honor. So the reality is, if he's on a GPS, I mean, we'll know where he is
Right.
at any given moment. So
Okay. Thank you, Mr. Lee. Thank you, ma'am.
thank you, Your Honor. And Your Honor, the next I have is Rico
Hold-
Williams.
Hold on one second. Mr. Lee, I knew I had a last thought, and you're fine. You can just stand there. Your attorney never stops advocating. I mean, that's a plus. She kept saying, well, what about this, and what about that, and in the video. So just wanted to point that out to you. I would talk to your attorney first away from a microphone before you put anything on the record. Okay.
But,
Your Honor, the only thing Mr. Lee wanted to point out to the court was just that the charges that the state had previously announced as his prior record, he's indicating are from when he was younger, and that as he's grown and aged and matured, that he, has a very different outlook on things and how to conduct himself. So he just wanted to make sure the court was aware of that.
Good. Thank you. Thank you, sir.
thank you.
Ms. Jacob?
I have Rico Williams, Your Honor, in 23 CF 1913. Your Honor, Mr. Williams is present before the court. KDJ Court on his behalf. Your Honor, in this case, we are asking, this is a driving charge, one count of driving on a suspended license pursuant to habitual traffic offender. Your Honor, Mr. Williams was given a cash or professional bond. He is unable to pay any cash or professional bond in this case, and we are just simply asking that the court convert that to a signature bond. I did note in the motion that if you look at the first appearance paperwork, he did score for a signature or ROR bond.
Yes.
It was just the court put it as cash or professional first appearance.
To the state?
That's fine.
Okay. So the motion to modify bond is granted. It's now a $1,000 signature bond, Mr. Williams, so they'll let you out today, okay?
And Your Honor, I do have a written order, and I will fill it out and provide it to court here in just a moment.
Perfect. When will I see Mr. Williams next?
He's set for January 8th, Your Honor. I had to continue his cases because I was just recently appointed. But I have represented Mr. Williams a couple of times, and he's always kept in great contact with me, which I didn't have a chance to get into because the state agreed. So.
Great. Thank you, sir.
Call me when you get out.
I will.
And that's all I have, Your Honor. I'll do the order, and then if I may be excused after that.
Yes, ma'am. Thank you so much. Okay, then to the defendants that don't have attorneys. Let's start. I have James Lee Carter. James Lee Carter. I don't see Mr. Carter. It's in 20 CF 3390, 20 CF 1584. This was scheduled for 9 o'clock. It's now 9:58. What does the state seek?
State would request a capias, Your Honor.
A capias will be issued for Mr. Carter, and the first appearance judge will determine the bond. Next is David James Robert Fitzpatrick, 20 CF 1372. Hello, Mr. Fitzpatrick.
Your Honor, at this time, I am in receipt, thank you, Mr. Fitzpatrick, for sending it to me.
Yes, sir.
I'm in receipt. The underlying case that this was that this was a VOP on was dismissed. So at this time, the state would announce a dismissal of the violation of probation in 20 CF 1372.
Okay, Mr. Fitzpatrick, your case 20 CF 1372 is dismissed.
I do have a question.
Yes, sir.
As it pertains to the case. So basically, the charges were adjudication withheld, and I just wanted to ensure that adjudication withheld was, I'm not sure if this, is this terminating my probation?
No, we're just dismissing the violation. So you still maintain whatever adjudication you had on the underlying, the 2020 CF 1372. We just dismissed the violation of probation. So you still have, you're still on that term, and you still need to complete the original terms of whatever those terms were for that.
Understood. Well, basically, that was what I was here to speak about. Basically, the whole term of my probation, I've had family issues, unfortunately, back and forth in custody court, back and forth with new charges that, to my knowledge, have all been dismissed. And essentially what I was asking for today is to dismiss and auto-terminate 30 days with outstanding costs, send to collections with adjudication withheld, maintain. Your Honor, basically this probation is it's wrapping up at this point in time.
How much longer do you have on your probation?
This was supposed to be it. That's what my concern was, is because January, I think at some point.
Okay, hold on one second. Probation when?
January 10th, 2024, Your Honor.
Okay, thank you.
And essentially, this probation was violated not only from the new charge, but as from the financials. And essentially, I've ran into issues time and time again obtaining employment.
Okay, hold on one second. I'm worried about due process and notice to the state.
Hold on one moment, Your Honor. I may be able to.
So traditionally, Mr. Fitzpatrick,
$1,600.
I would say you need to put it in writing, and then we'll set it for a hearing, because the state needs to understand him. I need to do my homework, the state needs to do its homework, but it's trying to do that homework now with probation, so let's hold on.
Absolutely.
Good.
Your Honor, while you pause, may I?
Yes, ma'am. Thank you so much. Thank you, ma'am. Really good job.
Your Honor, at this time, the state would be willing to revoke and terminate, maintain the withhold of adjudication. He does have, I believe it's approximately what?
$500.52 to the clerk. The rest of it's cost of supervision.
And the state would have no objection to waiving the cost of supervision so that he can pay those costs to the clerk, however many days he wants, and the rest will go to collections after that.
Okay. Mr. Fitzpatrick, so your current supervision is revoked and terminated. That doesn't adversely affect your withhold, doesn't change that at all. How long will you need to pay the $100 and something?
No, it's 500 and something.
Oh, $500.
We're waiving the
Cost of
1600
supervision.
We're waiving the COS and arrearages so that he would just pay the.
So is this for the case numbers? Because there's 3 case numbers, I do believe. It's 2019 CF 675 for the record, 2019 CF 2843 for the record, and 2020 CF 1372 for the record.
Probation, you got all those?
We've got zeros on the first 2, and the 2013-72 says $500.52.
So he only owes it on the case that's on the docket today, which
Okay,
is the
the court
20
does waive the cost of supervision, all arrearages on that. How long will you need to pay the $500?
$500. I'd say 60 days, if that would be all right with you, Your
Yes,
Honor,
sir.
in the courts.
Why don't we do 90 days, just to make sure?
That works.
So
And
if you
any
fail-
extra, from what I understood, it was a grander amount. I mean, actually, never mind. My probation officer did bring up that she had waived the costs of the other probation, so that makes a little bit more sense to me now.
Good. Okay, so if you fail to pay the $500 within 90 days from today, then it will go to a civil lien or judgment, but your supervision's terminated.
Yes, sir.
Thank you, sir.
I appreciate it, Your Honor. Thank
Thank
you.
you.
And thank you, Mr. Gomez.
Next, I have Julia Hilliard, or Julia Hilliard. Let's go with Julia, that'd be better, wouldn't it? Trying to make you a different nationality, I think. 19 CF 1573. Does the state have an offer for Ms. Hilliard?
I can confirm she's substantially complied with her probation. I know I can't read
It's 19 CF 1573. and 19 CF 1912.
I just can't get the personal last name because the mother advisor was supposed to provide me with names and contact info, but it's like let her do so since she's gotten out.
Has she completed her public service hours?
That's one thing that I did complete 19 hours of it. I have 32 hours left, I think. But the issue was I don't have childcare at all. Like, I have to work overnights just to be able to work. So nobody, like everybody that I live with, they all work during the day, and I don't have like daycare at all. And I can't even afford daycare. I'm barely making like $300 a week.
But she hasn't completed community service hours.
That's it.
So she's got community service left, and she's completed treatment. She's paid all her money, all her fees.
I just have 32 hours left, that's it.
The
Mr.
state
Shaw.
would find that she's substantially complied, and we'd ask the court to terminate her probation.
Ms. Hilliard, certainly no downside to that. For you, your supervision is revoked and terminated, so you don't have to perform the 32 hours of community service work. Any financials that Ms. Hilliard owes? No. Okay.
Are you dismissing the VOP?
The state's dismissing the VOP, correct?
Yes, sir.
Yes, ma'am. So Ms. Hilliard, your supervision's over.
She had some hardships that I was reading about. It wasn't willful. She
So
complied
we
with
wish
all
you
the
the
treatment
best.
requirements and made all the payments.
Good.
She just had issues with things at home, so.
Yes, sir.
Yeah, I'm saying, I even wrote you a letter.
Thank you, ma'am.
You're welcome. Thank you so much.
Gregory Marler is next. 22 CF 1295. Does the state have an offer for Mr. Marler?
So as of right now, I believe this VOP is just here for, he has cost of supervision in the amount of $240, and he has court costs and fines in the amount of $765. The state would be inclined to give him more time to pay those if he would pay them.
Do you have proof of payment?
Yes, sir.
Okay.
He's paid in full, Your Honor, according to our screen.
Okay.
The VOP would be dismissed then at this time, Your Honor.
Okay, what about the underlying supervision?
He would,
Still ongoing?
He's passed term effective 2 days ago.
so we would revoke and terminate and dismiss the VOP.
Good. Mr. Marler, your supervision's over, and there's no violation of probation against you.
Okay,
Thank you, sir. Next is Tamla Morris. Okay. Ms. Morris?
Sorry about that, Mr.
No, you got a tag along with you.
Yes.
18 CF 3005. Does the state have an offer for Ms. Morris?
Yes, Your Honor, hold on one moment. I wanted to pull up the affidavit because the state is going to go with probation's recommendation on this. Probation's recommendation is that the supervision be reinstated with the following modifications: add a victim impact panel and complete a basic driver improvement course. It should be noted that the defendant had completed all of the prior requirements prior to this incident actually occurring and really only had fees remaining. The officer specifically requested that we not incarcerate and that we follow the recommendation of probation. And so given the passion that the officer showed, we're going to agree with that and just modify the probation to add the victim impact panel and to complete the basic driver improvement course.
And what would the adjudication be?
We would maintain whatever the adjudication was.
Previously adjudicated.
Guilty. Okay. So, Ms. Morris, what that means is that if you want to accept the state's offer, you would be waiving your right to an attorney. You'd be waiving your right to basically a judge trial for me to determine if you violated your probation. If you accept the offer from the state, you'd be adjudicated guilty. It's my understanding you previously were adjudicated guilty, that your current supervision would be reinstated. You'd have to successfully complete the victim impact panel and complete the driver's improvement course. There would also be a $100 cost of prosecution. If you don't want to do that and you qualify financially, I can appoint an attorney to represent you. What do you wish to do?
I wish to do that, Your Honor, but also can I ask this, because when me and my probation officer spoke on it, the first recommendation was she was going to put in there, I owe no more fees.
Right.
I'm completely everything.
Yes, ma'am.
And I wrote you earlier, about 6 or 7 months ago, about the early termination, what Stone had put on my original stipulations when I was done.
Yes, ma'am.
So I completed successfully the community control first, and then now my probation.
Right.
Just in the course of that, I got that. So my officer suggested that she don't put the early term on there because she didn't know what the state was going to offer or what you were going to say. So I have no more requirements, so I'm asking, upon that completion, will I still be eligible for my early termination?
Okay, probation.
Your Honor, our screen shows $429.64 to the clerk of court.
I paid it already.
Okay.
Where'd you
Okay.
pay it?
JPay and
When?
officer, I paid it like last week or like 5 days ago, but
right,
Miss,
let me look, see if it's in
she
the-
said that it takes like 3 weeks before it hit the courts and before it show
No,
up.
it takes 1 day. It's not showing. The last payment was 11/10/23. It still shows a balance of 514.43 total.
And even if it's saying something else, it don't matter, I'll pay it.
Okay. So to the state, that make any difference to your offer?
No, we would maintain it all. If she completes those 2 things and gets it paid, then we'll term whenever she does that.
Is the victim impact panel, is that the MAD? Because Officer Johnson said the MAD program and the advanced trial.
Yes, it's put on by Matt, if I'm not
Okay.
mistaken. Yes.
Well, I agree with that.
Okay. If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. So, Ms. Morris, did you understand everything that the state said and also that the court said about your case?
Yes, sir.
And you understand that you're waiving your right to an attorney and an evidentiary hearing on the violation of probation?
Yes, sir.
Ms. Morris, I do accept your plea. You're adjudicated guilty. Your current supervision is reinstated. You'll need to successfully complete the victim impact panel, the driver's improvement course, pay the $100 cost of prosecution. The other terms of your supervision, you'll need to do that. However, once you complete that, then your supervision will automatically terminate.
Okay.
Okay?
Thank you.
Thank you, ma'am.
Appreciate it. Y'all have a good
Yes,
day.
ma'am. Cassim Wright is next. Thank you. Hello, Mr. Wright. Good morning, sir. 23 CF 1618. Does the state have an offer for Mr. Wright?
David.
I'm not sure.
Okay.
What is the?
What's the recommendation from probation?
That's what I'd like to know.
Look it up on Twitter.
I've been looking it up for 30 minutes.
Yep. Probation on Cassim Wright, 23 CF 1618. Do you have a recommendation?
Hang on, Your Honor, I have to look it up on the clerk.
Let's hear what the state's offering, and then you can decide what you want to do. If you want me to appoint an attorney because you qualify financially, then I'll do that.
Yes, sir.
But let's see what the state's offering.
Your Honor, the following is probation's recommendation. The officer is recommending a guideline sentence of a period of incarceration. The officer believes the offender is no longer amenable to supervision. The offender was ordered to supervision on...
Okay. Yeah, I think you can stop there. So prison is the offer from the state?
Hold on one moment, Your Honor. Let me look up I just want to look up the score sheet to see what we would be looking at.
Say something, sir.
Hold on one second. I don't want you to say anything that'll hurt your case. So let's see what the state's offering you, and then let's talk about an attorney. And if you're represented, talk talk to that attorney first before you put anything on the record.
Your Honor, this, as of right now, there isn't a score sheet in this file. So we would, if we can pass this, maybe until Monday, just to give us some time to get a score sheet together on this violation of probation, and then we can submit, we can give a more formal offer on Monday.
Okay, so right now, Mr. Wright, state isn't offering you anything. Do you want me to appoint the public defender if you qualify financially?
Yes, sir.
Okay, how much money do you make per month?
I'm on disability.
So how much have you averaged
About
make?
$800 a month.
I do appoint the public defender to represent you. Mr. McKinney's approaching on your right. What's the date, Monday? Gotcha. Got it. There's a discount. We are slow. Even that didn't have a...
Judge, this is a violation of probation arraignment.
Yes, sir.
We would enter a denial and ask for a court date to be set without subpoenas. I'd ask for one of the first dates in December.
Okay.
December 11th.
Yes, ma'am. Let me get to the right year. I'll be in December 11th at 9 o'clock.
Yes, sir. And if we reach an agreement ahead of time, then I can certainly reach out to the court.
And bring in Mr. Wright next week if you enter an agreement.
Yes, sir. I'd like to get a file open, speak to Mr. Wright, and speak with the state. And if we can resolve this matter next week, I'll certainly try to do so.
Sounds good. Thank you, Mr. Wright. Okay, then the public defender.
Reset for 11/20.
No, 12/11.
Set for
12/11.
December 11th.
Judge, I have Juan Garcia in the courtroom.
Okay, thank you, Mr. McKinney.
Mr. Garcia is approaching in 21 CF 2658. In that case number, he was on supervision with JCS for a misdemeanor. He did show that he has finished his DUI school, which is what we've been primarily tracking this all along for him to complete. So at this point, I believe the state would be in a position, if we admit the violation of probation, to revoke and terminate his supervision in 21 CF 2658 and send any outstanding financials to, I'd ask for time for Mr. Garcia to pay those amounts before they go to civil judgment or lien.
To the state?
That's correct, Your Honor, that we are in agreement with that.
Okay. Mr. Garcia, no downside to you for that, so the violation of probation is dismissed. Your current supervision is revoked and terminated. Probation, do you know how much Mr. Garcia owes?
Yeah, he's admitting the violation.
Oh,
Technically, it's an admission to the violation of probation. The agreement with the state is for his supervision to be revoked and terminated.
Thank you.
And he is on supervision with JCS, so probation in the courtroom is not going to have the dollar amount.
Okay, then Mr. Garcia, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. Put your hand down. Let me make sure I understand. So he would be admitting the violation of probation?
Correct.
The adjudication would be what?
He's previously been adjudicated at the misdemeanor.
Okay.
This is a misdemeanor.
And so he'd be waiving his right to an evidentiary hearing on violation of probation.
Correct.
You'd be admitting the violation of probation. You'd be adjudicated guilty. You'd have to pay a $100 VOP fee and a $150 public defender's fee, but your supervision would then be terminated. Is that what you wish to do? What did I miss this time?
Any outstanding financials?
We'll talk about that.
Yes, sir.
Right?
Yes.
So,
Yes,
okay.
Your Honor. That is
So you're adjudicated guilty, you'll need to pay that $100 and $150. Probation, what amount of money does Mr. Garcia?
He's on supervision with JCS, so state probation's not going to know.
It's about $888.
Okay. So it's 9, 10, 11, it's about $1,100, including those other two amounts that I just added. How long will it take you to pay those amounts?
About 120 days, Your Honor.
Okay. Why don't we do 6 months, okay?
Okay.
So if you fail to pay them within 6 months, that amount, then they'll go to a civil lien or judgment.
All right.
Okay? Thank you, sir.
Thank Thank you, Your Honor.
Yes, sir.
Yeah, thank you. Be sure to talk to JCS to make sure. Judge, I'll pass it over. The remaining individuals I have are incarcerated.
Okay. Folks in the gallery?
I just have two, Your Honor.
First, I would call Andre Blackman.
Mr. Blackman is present and approaching. Your Honor, we have reached an agreement with the state to resolve this. At this time, Mr. Blackman would admit violating supervision. The agreed-upon disposition is that he would be reinstated to supervision, reimposed as prior conditions of supervision. He would be assessed a $100 cost of prosecution, $150 in public defender fees, and he was previously adjudicated.
Okay.
May I approach?
Yes, sir. Mr. Blackman, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. Mr. Blackman, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes.
Did you sign it?
Yes.
Mr. Blackman, I do accept your plea. You're adjudicated guilty. Your current supervision is reinstated. You'll need to pay the $100 cost of prosecution, $150 public defender's fee. Thank you, sir. Good luck to you.
And, Your Honor, we will submit a score sheet, but that is a downward departure based on negotiated plea.
Downward. Yes, ma'am. Thank you.
The only other one I have in the gallery is Donovan Newsom.
Ms. Newsom? Mr. Newsom?
Mr. Newsom is present, Your Honor. We do have an agreement to resolve this. At this time, Mr. Newsom would be admitting violating to allegations 2 through 4 in the report. The agreed-upon disposition is that he would be reinstated to complete the original term of community control. So his original term of community control, I believe, expires in February, I think. So he's going to be put back on that until that term date. He originally was going to follow that community control with 2 years of regular probation. This agreement is going to modify that following probation to drug offender probation with a curfew from 10 to 7. And is going to add 26 additional hours of community service. And just so the court's aware, I accidentally wrote community supervision, so I just scratched that out and wrote service. He'll be assessed a $100 cost of prosecution, $150 in public defender fees, and the state would agree to continue Mr. Newsom's withhold.
Okay.
May I approach?
Please. Mr. Newsom, if you'll raise your right hand. Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor, I do.
Thank you, sir. Mr. Newsom, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Most definitely.
Did you sign the plea agreement?
Yes, sir.
Mr. Newsom, I do accept your plea. Adjudication is withheld. Your current supervision is reinstated and modified. Modifications are the probation will be drug offender probation. Your curfew will be 10 p.m. to 7 a.m. You also need to perform an additional 26 hours of community service work, pay the $100 cost of prosecution, $150 public defender's fee, probation.
Your Honor, do you want the curfew adjustable for work?
Yes, ma'am, please. Thank you, probation. Thank you, Mr. Newsom. Good luck to you, sir.
Thank you, Your Honor. Thank you.
All right, man.
Keep it with me.
Okay, Mr. Carter?
What happened?
James Carter.
The capias is withdrawn from Mr. Carter. This is 20 CF 390. Does the state have an offer for Mr. Carter?
Your Honor, if I'm not mistaken, in looking at the violation of probation, I believe this is mainly a monetary issue. The defendant does score prison with this violation, so the state would like to give the defendant some more time to complete his monetary obligations, and if he does, then we would dismiss the VOP and then revoke and terminate, because I believe all he has left is the financials.
Probation, how much money? Mr. Carter, they love when I ask them that. That'll hurt. You may be quicker.
Well, they have a different amount because of the cost of supervision.
Gotcha.
$2,942.88.
Thank you. Okay. So you're willing to extend Mr. Carter's probation, just where he can pay that off, and then if he, I guess, continue this hearing for some period of time where Mr. Carter can pay that off, and if he pays it off, then you'll dismiss the violation of probation.
That's correct, Your Honor.
Okay. Mr. Carter, do you want to do that, or do you want me to appoint a public defender?
Public defender, I believe.
Okay.
Or just a continuance to give me more time?
How much time do you think you'll need to pay?
At this
Almost.
point, I'm not working, I can't work, I'm filing for disability.
Okay. To the state?
Hold on one moment.
Yes, Your Honor. And let's don't forget, we have Ms. Dunford on Zoom.
All right, Your Honor, I think, so I'm trying to avoid this cycle of sending people back to probation. If he has no ability to pay the money, then I think what we would do at this time is just admit the violation and revoke and terminate probation and send the outstanding money to collections or to a civil lien.
Okay. So, Mr. Carter, what
We're
that
also,
means,
the reason why I'm also offering that is because he's at the end of his term as well, and so it's one of those situations where it doesn't seem like he's going to have time to pay or the ability to pay, so.
and the adjudication would be
I would maintain the adjudication.
guilty?
yeah.
Okay. So, Mr. Carter, if you want to accept that, you'd be adjudicated guilty. You'd be admitting the violation of probation. Your current supervision would be revoked and terminated. The outstanding financials, including a $100 cost of prosecution, would then go to civil lien or collections. Is that what you wish to do?
Yes, sir, that sounds good.
You'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Did you understand everything that I just told you, Mr. Carter?
Yes, sir.
Any questions for the court? I do accept your plea, Mr. Carter. You're adjudicated guilty. Your prior supervision is revoked and terminated. All outstanding financials, including the $100 cost prosecution, will go to a civil lien or judgment, and your current supervision is revoked and terminated.
Thank you.
Thank you, sir. Who represents Ms. Dunford? Okay. Oh, okay. So Katrina Dunford is on.
She is not on the docket, that's the mother.
Correct.
Who's incarcerated on the 235.
Okay. So, Ms. Dunford, your son will be appearing at 2:30 this afternoon.
Your Honor, on Mr. Dunford, so we had filed a motion to dismiss. However, Mr. Dunford is scheduled to be evaluated tomorrow on the state's last motion for an evaluation. My office reached out to your office last week and asked the court if the court intended to keep the motion to dismiss on this date or if the court wanted to have that evaluation. And we were informed that the court was going to defer till that evaluation is completed. So I met with Mr. Dunford yesterday, explained the situation, told him basically that I believe that this was mainly going to be a status conference. But I did inform Mr. Dunford that I intended to set the motion to dismiss for a hearing on December 11th. Or maybe possibly the 16th, if the doctor indicates that they need a couple more days to write the report. I will say APD's evaluators get their reports written pretty quick.
Okay.
Judge, she is here, he's just on the other side of the book. They bring him out, it'll take just a minute.
Okay.
He's aware of what's happening today.
Okay. So you want to waive his appearance, and then we set it for?
We can waive the appearance, reset it for December 11th, and I'll notice that motion to dismiss for a hearing on that date.
Okay. We need it in the afternoon? Is it going to be?
I believe it would be in an afternoon docket, Your Honor.
Okay. So, Ms. Dunford, I'm rescheduling this hearing until December 11th at 1:30. Okay? Thank you, ma'am. Thanks, Ms. Dunford.
Thank you, have a good day.
You too. Okay. Thank you, Mr. Kleins.
Yes, sir.
And you'll let? Good. Thank you, ma'am. Okay. Any other folks in the gallery that the PD represents? Okay. Since it's 10:30, let's take a 10-minute recess, and then we'll come back and finish up the morning. Thank you.
All right.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com.
Tire pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446.
Ma'am, Rachel?
Ricky Ramsey with Mr. Koch.
Thank you. Hello, Mr. Koch.
Good morning, Judge.
Good morning, sir.
Hello, this
Yes,
is
Judge.
Chris Norman. at
We're here in
Bulldog.
23 CF 1835. This is set for Monday, the plea or trial. Sworn affidavit has been provided from the alleged victim in this matter to the state. We set it also for today to see if we could possibly, if it was right to be null prost, but it is not. So I'm requesting if we could just leave this on Monday to be resolved.
Okay. Okay, say that one more time. Because I was looking for the paperwork and I don't have any. It just said status conference. So tell me what's going to happen on Monday?
Judge, I'll let the state talk, Judge.
Okay.
He's put in a recommendation to me. I told him I would review it and I could have an answer for him by Monday.
Okay.
So.
Okay. So, Mr. Ramsey, I'll see you on Monday at 9 o'clock.
I got another issue too.
Okay, why don't you talk to your attorney first away from the microphone, and then if you want to say it after talking to him, you can. And then, we also...
Yes. You just walked in. Are you ready?
Yeah.
Okay. You can also put number 6, Mr. McDonald.
You'll not have your misdemeanor charge on Monday. The state looks like it's being over. They're trying to say for me to understand they need to get out. But it can't be done. It's not on this court. Judge, thank you.
Yes, sir. Mr. Ramsey, I'll see you on Monday.
Next, we're going to do Michael Duncan, Mr. McKinney.
Okay, Mr. McKinney.
He also has a case on May 1/3.
Okay, thank you.
Judge, this is Michael Duncan, Jr. before the court. Mr. Duncan is here in a variety of different case numbers on different dockets. So for the court's benefit, he does have 23 CF 2093. In that case number, I would acknowledge the receipt of a 6-count information, waive its formal reading, enter a plea of not guilty. This is scheduled for the January 8th pretrial court date. That's on the 1:30 docket. His other case that was already in this division was scheduled as a status this morning because we had the arraignment. That case number is 23 CF 1380. I would ask that that be continued to the 1/8 docket to match 23 CF 2093. And he has 3 violation of probation cases, 23 CF 912, 23 CF 304, and 21 CF 2830, that if denials have not already been entered, I would enter a denial and ask for them to track with the 2 cases on the January 8th pretrial court date. 4 of these cases were transferred down from Crestview, so I just wanted to make sure that we get them all together and moving in the same direction.
Good. Mr. Duncan, I'll see you on all of your cases on January 8th.
And Judge, we have filed a motion for bond not to be heard today, but scheduled for December 11th. So that's the next time that you would see Mr. Duncan in the courtroom, and then he would have his pretrial on January 8th.
Sounds good. I'll see you then. Thank you.
Jimmy McDonald from Mr. Catalina.
Hi, Judge.
Come on, Mr. Catalina.
Doing well, thank you. Your Honor, we're here on Jimmy Wayne McDonald, case number 23 CF 1469. We're here to reinstate his bond, Your Honor. On July 1st, he was charged with aggravated battery using a deadly weapon. He was released on bond on July 18th. He was charged with property damage, criminal mischief over $1,000, a third-degree felony. The accusation was apparently there was an argument and my client kicked some guy's door in on his vehicle, did some damage to his door. We're asking, Your Honor, if the court will be gracious enough to reinstate his bond. Thanksgiving is coming up. He has a place to work, he has a place to stay. It's not a violation of probation. I know that it's been 16 days since this happened, but it's unbecoming of him. Is that not right? And Judge, we're asking for a reasonable bond if the court would agree to some type of GPS, pretrial services where he has to check in physically once a week. That will be gracious by the court.
She's taking a look at it. Okay, thank you. To the state.
Your Honor, I just want to point out, we had a bond hearing on this same exact issue on September 14th. The state is aware, and there has been no allegations in this most recent motion to reinstate bond of any material change in circumstance that would warrant a reinstatement of this bond. However, on top of that, and this is the same argument I made in September, the underlying charge in 23 CF 1469 is aggravated battery with a deadly weapon. We then have another instance where if you read the report in the 1880 case,
yes, sir,
this isn't just a simple, I destroyed some property. He destroyed the property out of anger. He was very upset. And so given that, we would request that this bond remain revoked on the 1469 case as he committed a new law violation while out on bond, and there have been no material change in circumstances from the last bond hearing that we had in September.
Mr. Catalina, what's changed between the last bond hearing and this one?
Your Honor, what's changed?
Correct.
I didn't do the first bond hearing, Judge.
Okay. Did you look at that prior hearing?
No, sir.
That prior bond? Okay. Mr. McDonald, when I was doing my homework, I didn't see the prior bond hearing when I was doing my homework. But looking through the information and, you know, I looked at the bond, at the motion, and saw criminal mischief, $1,000. And I go, yeah, you know, that he should probably, why should he stay in jail because of that? Then the same thing that the state argued, I went back and looked at the arrest report for that criminal mischief, saw what's alleged in there, and because of what's alleged in there, respectfully, your motion to reinstate the bond is denied. So when will I see Mr. McDonald next? January 8th or some other time?
That's what he set for you.
I believe so, Your Honor.
I'll see you on January 8th.
Your Honor, I have an order. May I approach?
Please. Thank you. Thank you, sir. Thank you. Yes, sir. You too.
She said she's going to talk to them and see what happens today. She thinks
It's going to be dismissed. Yeah, she doesn't need to see what happens.
I know. That's what she told me. So
Okay, thank you.
we'll be able to get it resolved.
Who is this, Your Honor? Rubens.
She's here with me, all right? Yes, Judge.
Yes, sir.
I got Mr. Rubens to my left here in 22 CF 2311. Your Honor, my client returned from the state hospital on 11/9. So we're here today to, I guess, put him back on our docket. So I'm requesting to be placed on the pretrial the January 8th, Your Honor.
Okay, first do I need to make a determination of his competency?
Yes, Judge. State has reviewed the letter from Florida State. We would have no objection to the court reviewing and finding him competent to proceed in this matter and putting it on the next pretrial docket.
Okay, and when you say from the state, that's Brandon Cooper's competency evaluation?
Let me see, look at the name.
The date of the evaluation was October 26th of this year.
Yes, Judge.
Okay. I do find Mr. Rubin competent to proceed. Okay, so January 8th?
Yes, Judge, please.
Mr. Rubin, I'll see you back here on January 8th, okay?
Okay.
Thank you, sir.
Representative Matthew Townley with Mr. McKinney.
Thank you.
Judge, this is Mr. Matthew Townley before the court in 22 CF 1085. His mother and father are present in the courtroom.
Good.
We have reached an agreement in this case.
Thank you so much.
Did you have a chance to review it?
Yeah.
This is a violation of probation.
Thank you.
The agreement that's been reached with the state for an admission to the violation of probation is for an adjudication of guilt, reinstatement of his supervision to complete the original conditions, and to modify those conditions to include ALR Cottages Sober Living in Pensacola. That is a 6-month residential program instead of the Haven House. There would be a $100 BOP fee, $150 cost of defense. The supervision will be modified to drug offender probation for the remainder of his supervision. That typically includes a curfew, that we would ask for the standard curfew and ask for probation be allowed to modify it for a work, school, or the program. This program has an admission fee of approximately $700, and that it's $210 weekly. That's not part of his supervision, but we're asking the court to waive the cost of supervision because of the added costs for the ALR Sober Living, which his family is helping him complete.
Okay, thank you. Has Mr. Townley been previously adjudicated guilty?
Yes, Your Honor, he has. And there's going to have to be some discussion on how are we going to get out of jail and to ALR, but that's something that I want to put on the clerk's minute sheets after we enter the plea.
Okay, so it'll be bars to bet.
They do not come pick him up at ALR, which means if we would structure it so that he could be released to his mother at 8 o'clock tomorrow, his mother would be transporting him to probation first to check in with probation, then to ALR. So I believe that the state wants him to be at ALR by 5 o'clock tomorrow. Is that correct, Mr. Snell?
Yes, sir.
That way he would effectively be going straight from jail with his mother to check into probation and then straight to ALR.
Good.
May I approach with the plea agreement?
Please, Mr. Townley, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can put your hand down. Mr. Townley, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Townley, any questions on what the sentence is going to be?
No, sir.
Okay. The curfew, Mr. McKinney, 6 p.m. to 6 a.m., other than when he's in ALR?
Yes, Your Honor. We'd ask for that to be able to be modified by probation.
For work or school?
Yes, Your Honor.
Mr. Townley, do you agree to that?
Yes, sir.
Okay. Mr. Townley, I do accept your plea. You're adjudicated guilty. Your current supervision is reinstated and modified. So it is drug offender probation, 6 p.m. to 6 a.m. curfew. You'll need to enter and successfully complete the ALR Cottages program in Pensacola. The court does waive the cost of supervision while you're in that program. You'll need to pay the $100 cost of prosecution, $150 public defender's fee. You will be released tomorrow morning at 8 o'clock to your mom.
That is Melissa, common spelling Townley.
Okay. And
if we can put that on the clerk's minute sheet.
Yes, sir. And your mother then will take you immediately to probation where you'll report, and then you'll need to be at ALR no later than 5 p.m. tomorrow.
Yes, sir.
Okay. Staying with your mom the whole time. Okay. Mr. Townley, if you look around the gallery, your folks are about the only ones that are left. They've been here all morning for you. They support you, as is evident by your mom agreeing to do what she's going to do tomorrow.
Yes, sir.
I wish you the best, sir.
Yes, sir. Thank you.
Thank you.
Thank you. Okay. Good to go? Yes, sir. Yeah, good to go. Thank you.
We're going to do Samantha Singleton Norton. She's also on the 130 docket.
Okay. Thank you.
Yes, sir. If I just may have a moment just to sign the plea form, Your Honor.
Good morning.
So that's that VOP we talked about. Whenever you're ready, I'm going to ask you to sign it. Any questions?
You already know my questions.
Okay, all right. If you sign right there, and it's the 16th, if you can. Yes, and that's why we, yes. Now this is the new law we talked about. I did add maintain gainful employment, or just show proof of 5 job application, okay? And then that same thing, 16.
Yeah, this is what I was talking about here. I don't know.
A lot of this, that doesn't apply to you. It's the terms that we talked about in here, okay? Yep.
Hey, the new case, what's that case number?
19 CF 1524.
And the new law is 22 CF 1784. All right, thank you, Your Honor.
Thank you.
We are here on a violation of probation, Your Honor, in 2019 CF 1524. My client will be admitting to the violation. Be 60 days, Okaloosa County Jail. Revoke and terminate probation, credit for any time served already, and there's the $100 cost of prosecution and the $150 for the defense costs.
And the adjudication on that?
It's adjudicated guilty, Judge.
Okay.
And then my client's also here on a new law violation, and this is 2022 CF 1784. I did put it on a different plea form just because in the new law it will be a withhold of adjudication.
Good.
And for the new law, it is withhold adjudication, 36 months of probation, $615 in court costs, $100 for the defense costs, must complete the substance abuse evaluation within 30 days, and then any recommended treatment within 60 days, 50 hours of community service, while on probation, cannot consume or possess alcohol, no possession of drugs without a prescription, random urinalysis, random breath test, and maintain employment or 5 job applications per week. If I may approach with the plea form.
Yes, sir. Thank you. Thank you, sir. on the VOP case, was that a misdemeanor?
Originally, it was a lesser, so they were misdemeanors, Judge.
Good, okay. Ms. Singleton Norton, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Did you read the 2 plea agreements?
Yes, I did.
Do you understand them?
Yes, sir.
Did you discuss them with your attorney?
Yes, sir.
Did he answer all of your questions?
Very much.
Are you satisfied with his representation?
Yes, I am.
Did you sign the plea agreements?
Yes, sir.
I do accept your plea on the VOP case. You're adjudicated guilty. You're sentenced to 60 days in the Okaloosa County Jail with credit for all time served. Your supervision is revoked and terminated. You'll need to pay the $100 cost of prosecution, $150 public defender's fee. Mr. Koch, do you want the financials from that to go directly to a civil lien, or do you want them to go into the other probation?
If we put it to the other probation, Judge.
Okay.
Please.
So all outstanding financials from that case will be paid during the 36-month probation in the new case. In that case, adjudication is withheld, 36 months probation. You'll need to pay the court costs, $100 cost of prosecution, $40 per month cost of supervision, submit to a substance abuse evaluation within 30 days from the time you're released from the jail. If any treatment's recommended, begin that within 60 days from your release from jail. Perform 50 hours of community service work. You'll have no alcohol, no drugs during your supervision, no drugs without a valid prescription. You'll need to submit to random urinalysis, random breath tests. You need to maintain gainful employment or perform 5 job applications or fill those out per week.
Yes,
Okay,
sir.
thank you, ma'am. Good luck to you.
Will they be taking any action on the FTA for the 22 CF case?
On the FTA?
Just so that the jail knows when she needs to be released?
Not at this time, no.
Thank you, ma'am.
Thank you.
You're welcome.
Hello, Mr. Pritchard.
Your Honor, if I just may have a moment to sign.
Certainly.
Have you read it? Any questions from me? Okay. Sign right there.
Excuse me.
Today's the 16th. 11/16.
Oh, you did? Okay. Probably. I just carry it in there. Mr. Pritchard, we're laughing because Judge Heflin, who was on the bench well before me, he was my mentor judge, actually. At one point, he was in a hearing, and he said, "I'm sorry, I couldn't hear that. I got coughed out." And so we're laughing at coughing and being able to hear. Yes, sir. Mr.
Yes,
Cox?
Your Honor. This would be a change of plea of no contest. In counts 1 and counts 2, it'll be a withhold of adjudication, 3 years probation, substance abuse evaluation within 30 days, any recommended treatment within 60 days, 24 hours community service, $615 for court costs, $150 defense cost, and then the $40 per month cost of supervision. Count 3, Your Honor, will be credit for time served.
And adjudication of guilt or what?
Yes, Judge.
Okay, thank you. Thank you. Mr. Pritchard, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Your Honor, I'm sorry, I just want to clarify because I just heard something. I believe it's supposed to be a withhold.
On the misdemeanor?
Oh, my bad, sorry. Okay, I just want to make sure. I'm sorry. Apologize.
Mr. Pritchard, did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Yes, Your Honor.
Did you discuss it with your attorney?
Yes, Your Honor.
Did he answer all of your questions?
Yes, Your Honor.
Are you satisfied with his representation?
Yes, Your Honor.
Did you sign the plea agreement?
I did, Your Honor.
Mr. Pritchard, I do accept your plea. Adjudication is withheld on counts 1 and 2. You're adjudicated guilty on count 3. You're sentenced to credit for time served on count 3. Sentenced to 3 years probation on counts 1 and 2. That's to run concurrently, run at the same time. You'll need to submit to a substance abuse evaluation within 30 days from today. If any treatment's recommended, begin that within 60 days from today. Perform 24 hours of community service work, pay the court costs, $150 public defender's fee, and the $40 per month cost of supervision. Thank you, sir. Good luck to you.
Thank you, Your Honor.
You're welcome.
Next will be Colby Rhodes.
Yes, Your Honor. My client is here on the violation of probation in 23 CF 832. We'll be entering a denial, and my client does have a new law offense in this division, which is 23 CF 2396, if we may address. At this time, the Public Defender's Office hasn't been appointed on the new law.
Okay. Has an information been filed?
Yes, Judge.
Okay. Mr. Rhodes, do you want the public defender to represent you on your new case?
Yes, Your Honor.
Okay. I do appoint the public defender to represent you on that case.
What was that case number again?
23 CF 2396.
Defense would just request we keep them together and place them on the January 8th pretrial.
Okay. So, Mr. Rhodes, I'll see you on both of your cases on January 8th. Thank you, sir.
Next we have Brandon Roswell, he's on the 130 docket as well.
So did you want to go ahead and enter not guilty plea for that other case because it's set for 12/14 felony plea day?
Mr. Koch.
I'm sorry, Judge. For Mr. Rhodes, it would be a not guilty, yes.
Okay, thank you.
Thank you.
Hello, Mr. Roswell. Or is it Roswell?
Yes, sir.
Good.
Judge, if I just have a
Yes,
brief
sir.
second. You're welcome. Thank you, Judge. My client is here on a violation of probation, 22 CF 1567. We'll be entering denial, Your Honor. And the new law offense, 23 CF 2327. The state did file formal charges. We'll be entering not guilty and request that they both be placed on the 1/8 pretrial docket.
Okay. Mr. Roswell, I'll see you back here on both of your cases on January 8th.
Yes, sir.
Thank you, sir.
Thank you. Bless you.
Thank you, sir. You too.
Next will be Donald Stain.
Hello, Mr. Stain. Good. How are you?
Fine, so far.
Good.
I keep the shoe on.
Yes, sir. Yes, sir.
Your Honor, if I just may have a moment for a signature.
All right.
Do have to go home with me.
Five, 2019 CF 3450 and 2020 CF 1006. Your Honor, we'll be admitting to violations. It'll be 60 days Okaloosa County Jail, credit for time served, revoke and terminate probation, $100 for the cost of prosecution, and then the $350 defense cost, Your Honor, if I may approach.
Okay. So there's 3 VOPs, so it's $100 times 3.
You're right, Judge. I apologize if I can have a moment.
And the adjudication is what?
It'd be adjudicated guilty, Judge.
Thank you.
Because there's 3 cases, it is 300 instead of 100 here. Okay?
Mr. Stain, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down.
Yes, sir.
Mr. Stain, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Stain, I do accept your plea. You're adjudicated guilty. You're sentenced to 60 days in the Okaloosa County Jail. That's to run concurrently, run at the same time in each case and count. And that's with credit for all time served. your prior supervision's revoked and terminated. You need to pay a total of $300 in cost of prosecution, $350 public defender's fee. How much does Mr. Stain owe in his probation? Probation, do we know?
I think I know.
It's
Mr. Stain, and you may know approximately how much you owe.
About $1,700, I think so. Court cost.
1724.
That's it.
Okay. So it's going to be over $2,000, probably close to $2,200. Do you want a period of time to pay that after you get out of jail, before it goes to a civil lien, or do you just want it to go to a civil lien?
What do you think? Your Honor, if I could have 6 months, that would help me.
Okay. If you fail to pay it within 6 months, then it will go to a civil lien or judgment.
Yes, sir.
Thank you, sir. Good luck to you.
Good luck. Thank you, sir.
Thank you, sir.
Yes, sir.
Hello, Mr. Stansberry. Mr. Koch?
Yes, Judge. Today we'll be entering denial, Your Honor. And if we...
Your Honor, on the way back to counsel, Mr. Koch has made no effort to contact me in the jail, written or anything at all. I didn't willfully violate probation.
Okay, hold on. Okay, we got to go through you want to represent yourself first. Okay. Traditionally, that's done in writing. Do I need to get that in writing? I think so, too. So, Mr. Stansberry, if you want to do a motion to represent yourself, yeah.
Like I said, the day after I signed up for
Okay, wait, hold on. Okay, hold on. I don't want you to say anything that'll hurt your case. That's why I'm stopping you. You want to represent yourself. You aren't saying that Mr. Koch is providing ineffective assistance, but you just want to represent yourself. You don't want another attorney.
No, Your Honor, and I want to see if the state has an offer today.
Okay. Okay, let me ask y'all, as far as how many folks do we have left in the back?
Like 15, 20.
Okay.
For this morning.
So then, Mr. Stansberry, I'm going to ask them to bring you back out. If we finish with everybody that's back there before 12:30, I'll get them to bring you out this morning. If not, it'll be this afternoon, because I have a lot of questions I need to ask you.
Okay. Yes,
Okay?
Your Honor.
Thank you, sir.
Next we'll do Rodney Swain.
Thank you. Hello, Mr. Swain.
How you doing?
Good, how are you?
Well, I'm just in the circumstances.
Yes, sir.
If I should have a brief moment, Judge.
December 11th. The same spot we had the other guys. I think there's overlap in doctors, so you might as well.
Yes, Your Honor. I have Mr. Rodney Swain to my left. We're here in two cases, 2023 CF 1384 and 23 CF 1648. This will be a change of plea. I'm going to be adjudicated guilty. It'll be 14.175 months, Department of Corrections. Client will receive credit for all time served. There'll be $1,030 in court cost and $250 defense costs, if I may approach, Your Honor.
Okay, yes, sir. Thank you. So has Mr. Swain been adjudicated guilty in the past?
Yes, Judge.
And the sentence is concurrent, correct?
Yes, Judge.
Okay.
Thank you.
Mr. Swain, if you'll raise your right hand.
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. Mr. Swain, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
I am.
You,
Mental
okay.
health.
Have they prescribed prescriptions for you?
I have, but I'm not getting it right now, so.
Okay. What were you diagnosed with as far as your mental?
Schizoaffective, bipolar, I have several different diagnoses.
Okay. First off, what are the two charges against you on these cases? What are the crimes they allege you did?
Exposure.
Okay, exposure of what?
A sexual organ.
Okay. And then what will the sentence be if I accept your plea? What are you going to be sentenced to today?
14.17.
Okay, and where will you spend over 14 months?
DOC.
Okay. Just for the record, what does DOC stand for?
Department of Corrections.
Okay. Any questions for me or Mr. Koch or the state?
No, sir.
Okay. How far did you go in school?
8th grade.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Swain, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel. Are you satisfied with Mr. Koch's representation?
Yes, sir.
Of whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty. You're sentenced to 14.175 months with the Department of Corrections, with credit for all time served, to run concurrently, run at the same time. You need to pay the $1,030 in court costs. Is one of these a VOP? No, they're both new cases, so both court costs are in that amount?
It would be a little bit more because of the statute. It mandates the 151 rate fee, so it would apply to both cases, so it'd be an extra 151 in each case.
Okay, Mr. Swain, do you object to paying the $151 extra in each of the two cases that didn't reflect it on your plea agreement?
Judge, if I may.
He just signed on the probation in August. So he didn't really get started. But he scored prison and he downward departed.
Yes, sir.
You're okay with that?
Yes, sir.
Still want to enter the plea?
Yes, sir.
Okay. You'll also need to pay the total of $250 public defender's fee. Mr. Swain, do you want a period of time after you get out of prison to pay those, or do you want them to go directly to a civil lien or judgment?
A period of time.
Okay. How about 1 year after you get out? Okay. So if you fail to pay it within a year after you get out, then it will go to a civil lien or judgment. Okay. You do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, sir. Good luck to you.
Thank you.
Yes, sir.
Score sheet.
You're going to get me a score sheet, State?
Yes, sir.
Thank you.
Next, we're going to do Urban Arias Marquez.
Thank you.
Scott, I can get rid of the misdemeanor too.
Oh, cool. Your Honor, I don't have the case number.
Good morning, sir.
Figure it out real quick, hold on.
Do you have the case number?
No, I can grab it. I can figure it out.
Hold on.
Well, we just asked the clerk. Your Honor, this is Urban Arias Marquez in 19 CF 1687. I believe the state's going to dismiss this VOP, and Mr. Gomez just informed me that he's also going to agree to dismiss Mr. Arias Marquez's misdemeanor VOP, but I don't have that case number.
23 CT 466.
Thank you.
And that's the one on the docket. And the other case is 19 CF what?
1687.
Thank you.
And I just kind of wanted to be known on the record to Mr. Marquez, this is kind of the last opportunity that we have with this. We're trying to give you an opportunity because we know that there's been some weird hiccups with ICE and stuff like that, but this is really the last time that we're going to give you another chance. So just be aware of that. Okay.
I don't see any downside to that, so both case number 23 CT 466 and 19 CF 1687 are dismissed. Any probation that you're on, any supervision, that's revoked and terminated?
No,
Probation?
it's
No.
reinstated.
No,
It's
it's reinstated.
reinstated,
Yes,
okay.
Your Honor.
Thank you. Okay, so, okay, again, he's status quo, there's no downside, right?
Correct. He's just basically being put back on supervision to complete his original term.
So you still are on probation, okay? Probation?
He's on community control, he needs to report immediately upon his release from jail.
Okay.
Do we know what town he's living in?
Fort Walton.
Walton. He needs to report immediately.
So if you get out today, you've got to report to Fort Walton probation today. If it's after 5 o'clock tomorrow morning at 8 o'clock. Thank you, sir.
If
Good
it's,
luck.
if it's after 5, does he still have to call you guys to tell
He
you?
needs to call his officer.
Okay.
Do you have her phone number?
Yes.
Okay.
Okay.
All right.
Thank you, sir.
Good luck.
Thank you, thank you.
Next, I'm going to do Talisha Bias.
Thank you.
Yeah, you always hear about the children, always want the parents together.
Yeah.
Your Honor, this is Ms. Bias in 21 CF 480. She does have a 3-year suspended sentence. We are going to ask the court to set this with subpoenas for a hearing in the month of December. We'll leave it to the court on the date.
Okay. Madam Clerk, as far as timing, what would you suggest?
Would you want it in the afternoon, Your Honor?
Yes, ma'am.
There's there's 4 cases set on December 14th in the afternoon.
Let's do that.
Okay.
December 14th at 2:30. So I'll see you back here then, okay?
Okay, thank you.
Thank you, ma'am.
Next, we have Ashley Lester, she's on the 130 docket as well.
Thank you.
Your Honor, this is Ms. Lester. She is on the morning docket this morning on a motion to reduce bond.
Yes, sir.
If I could take some brief testimony from Ms. Lester.
Okay, do you want to do the first degree stuff first?
Sure, we can go ahead and waive formal reading, acknowledge receipt of a 2-count information, enter a not guilty plea, and
Okay.
ask that this remains set on the January 8th docket.
Good, thank you. Ms. Lester, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. I
Thank
do.
you, ma'am. You can put your hand down.
Okay.
So, Ms. Lester, if you're released on bond, where are you going to be living?
I have a apartment, a friend that has an apartment, the Ivy House, behind the Captain D's on Miracle Strip.
Okay. How long have you known this friend?
About 2 years.
All right. Are you
He's a retired military and older gentleman, very nice.
Are you originally from this area?
My family's lived in Destin since I was like 6.
Okay. What do you do for a living?
I'm mostly hospitality, server, bartender, but I also do art and music.
Does your family still live here?
Yes.
Okay. If you were released on bond, is your intention to come back to court on January 8th?
Absolutely.
Okay.
I love it.
Excuse me.
Right here.
I don't think I have any other questions.
Okay, to the state, questions?
No. No,
Okay.
Your Honor.
Thank you. Mr. Kleins?
Your Honor, Ms. Lester is in custody on 2 counts. Obviously, we just acknowledge receipt of 2-count information. $5,000 cash professional bond on count 1, $1,000 cash professional on count 2. She's requesting that the court reduce those to signature bonds. I have not received discovery yet, so I don't know what her score sheet's looking like. These are, unfortunately, I hate to say run-of-the-mill charges, but they are. I mean, let's be real. So we are just simply asking the court to consider reducing these. She does not appear to be any sort of a flight risk. She's got family in the area. And I would point out, Your Honor, in reviewing the report, Ms. Lester was allegedly in possession of this small wooden treasure chest,
Yes, sir.
which she was drawing on.
I don't think it said treasure, it just said chest, right?
Mine says treasure chest.
Oh, okay.
But
Maybe so.
some kind of a chest.
When I read it, I guess I just went past that, okay?
And she was drawing on it. Officers saw what appeared to be contraband inside, but I would point to the court's attention to post-Miranda, the defendant advised she found what was inside the box while she was walking. There's no allegation, at least at this point that I know of, that she ever acknowledged knowing what that substance was, and that's one of the key components of possession is knowing what the substance is. And so, again, I don't have discovery, I don't know how this is all going to play out, but we would just ask the court to consider reducing these signature bonds.
Thank you. To the state?
Your Honor, the state is opposed to reducing bond to a signature bond. We would not be opposed to reducing it to $2,500, but not signature.
Understand.
She has a prior failure to appeal.
How long ago was that?
2022.
Okay.
As well as a prior VOP.
Mr. Kleins, finally, anything else?
The only thing I'd point out, Your Honor, I don't have the statute number off the top of my head, but Florida does have a presumption for non-monetary bond release. So I would just point the court's attention to that.
Okay. Ms. Lester, it does concern the court that there's a previous failure to appear that was only a year ago, but your family living in the area since you were 6 and since they still live here, have you lived with this friend in Ivy House before, or are you just starting to live with them?
I stayed with them about a year ago before I started traveling. I was over in New Orleans doing some work for a while, and then I just made my way back up here about maybe 2 months ago, I want to say.
Okay. That also concerns the court about you appearing, but because of the charges, I'm going to grant the motion for bond reduction and make them both signature bonds, so you'll be able to sign out of jail. Make sure you stay in touch with Mr. Kleins.
Yes, sir.
Make sure you appear when you're supposed to. Is it January 8th?
Yes, sir.
So January 8th at 9 o'clock. Ms. Lester, you need to be back here, okay?
Yes, sir.
Thank you, ma'am.
Absolutely.
Can she be released on the minutes, Your Honor? I'm
Yes,
kind
sir,
of
she-
busy.
yes,
Okay,
sir.
we will get the court in order, though.
Thank you.
very much.
I'll see you in January.
Thank you.
Your Honor, this is Miss Munn. She is on today's docket in this morning in 22 CF 1344 and 20 CF 2911. We will enter a denial on those cases. I believe she's on this afternoon's docket for a new law violation in 23 CF 2172. Court gives me 1 second to fish out the information.
Sorry, who is this?
Ms. Munn, M-U-N-N.
Okay, well, since she's here, Your Honor, I will acknowledge receipt of a 3-count information that was filed on October 17th. We will waive the formal reading, enter a not guilty plea, ask that Ms. Munn remain on the January 8th docket. I did talk with probation today. I will talk to the state. Fingers crossed, I hope the court sees her again in the month of December, because that would indicate an early resolution. But she does have a 5-year suspended DOC sentence on these VOP cases. She's looking at a presumptive prison sentence on the new charge. I can't make any guarantees, but I know probation is relayed the progress she's been making on probation, so I intend to talk to the state about that and see if possibly we can get her back before you in December.
Okay. Ms. Munn, I'll see you on both of your cases no later than January 8th. I don't think I've ever seen probation wave at someone when they come out, so that was unique. Thank you, ma'am.
All right, hopefully we get something, okay?
Eric Lucas.
This is Mr. Lucas, Your Honor. He does have 2 cases, 23 CF 265 and 23 CF 1353. We will enter a denial today, ask that this be set on a date in December without subpoenas. He does have a 12.1-month DOC offer. I'd like to talk to him about that, but I would expect a resolution sometime in December.
Do you want it December 12th?
Sure.
December 12th at 9 o'clock. I'll see you then.
Yes, Your Honor.
Thank you, sir.
All right, come see you before then, okay?
December 12th, Your Honor, I show that it's set aside for your civil stuff.
It's the 11th, if I'm not mistaken, if I recall it from Monday.
I'm on the wrong year, aren't I? Okay. December 11th.
Trying to set it for 2024, Judge?
I think so. Okay.
Is it 12/11?
Thank you.
It's 12/11.
As soon as I heard 12/12, I was like, I'm just going to live in this courtroom.
Right, yeah, December, we're just in court, so.
I'm sorry, that's the 2024 calendar. Mr. Mathias, how are you?
Your Honor, I'd be better if we could resolve this.
Well,
Your
we'll
Honor,
learn
with-
together.
With Mr. Mathias, I did propose to the state today a resolution reinstating Mr. Mathias with a suspended 24-month sentence. Mr. Gomez has indicated the state's not in a position at this time to accept that kind of a counteroffer. All I can do is enter a dismissal today. I'm sorry, denial today.
We can do that, too.
Yeah, if the court wants to take the dismissal. But the denial today, and then ask that the court put this on December 11th to see if we can get some kind of movement on that situation. And if not, there potentially might be a bond motion at that time.
Okay. Why don't we do it December 14th, okay?
That's fine. Yes, sir.
So December 14th at 9 o'clock. So I'll see you no later than that. Thank you. Thank you, sir. You too.
Next we have Charles McDuff, he's on the 130 docket as well.
Got it. Thank you. Yep.
Your Honor, this is Charles McGuff. As to the 130 docket, we do have receipt of a one-count information in 23 CF 2336 that was filed today. We would waive the formal reading. I'm sorry, it was filed yesterday. We would waive the formal reading, enter a not guilty plea. I did talk with Mr. Gomez, and I believe the state is going to stipulate to reduce all of Mr. McGuff's bonds to signature bonds. It's kind of an unusual situation, how things are playing out with Mr. McGuff, but I'll pass it to Mr. Gomez to confirm.
Mr. Gomez?
Yes, Your Honor. The state would be okay with doing signature bonds in this particular instance. It's not something that we would normally make a habit of with these charges, but there has been some issues in regards to getting certified convictions and getting the identity right. It's kind of wild how this is unfolded. The only thing that I would impress upon Mr. McGaw is this is going to continue to be charged. If you get out of jail and you don't register, they're just going to turn around and do the same exact thing.
And so as of right now, I'm not registered?
As of right now, no, you are not registered.
Okay.
What I would advise you to do, Mr. McGuff, is when you are at the jail, ask them if you can register there for your address down on Church Street.
Well, that's what I did last time.
If they won't do that there, if I was in your shoes, I would go do that, and then I would go straight to a sheriff's office substation and ask to register there, and then I would go directly to the Department of Motor Vehicles and get an identification card.
Okay.
But you need to do that within like 24 hours,
Correct.
or else there's going to be this is going to be another cycle that we go through.
Yes, sir.
Tomorrow night at dinner, you should be fully registered, and people should be telling you to stop bothering them about registering.
All right.
Okay, so signature bonds on all three cases?
That's correct, Your Honor.
So on the new case, was there a bond previously set?
There was, Your Honor. The only thing I would ask is if the court would consider, it was $35,000 cash or professional. I would just ask if the court would consider reducing that to $5,000 signature.
Any objection?
No objection, Your Honor.
Okay, so $5,000 signature on the new case. All the rest of your bonds are converted to signature bonds, which, as a side note, Miami doesn't even know what that is, because I'm trying to do one of those in Miami, and they go, we don't know what to do with a signature bond. Pensacola's not real big on those either.
I've never heard of it until I came to Florida either.
Yes, sir. So it just means if you don't show up, you owe that amount of money. Okay? So will I see Mr. McGuff on January 8th? Or?
Yes, that would be my intention, and I just want to make sure, because I believe he also may be on Monday's docket, but because we're kind of squaring everything away, we just would ask to continue all three of these cases at the January 8th docket.
Okay. I'll see you on January 8th at 9 o'clock.
Yes, Your Honor.
Thank you, sir.
Let's talk in December, okay?
Yeah. Thank you, sir.
Your Honor, this is El Shabazz Neal. He does have two violations in 23 CF 1337, 22 CF 3042. We will enter a denial on those violations. I would ask the court for continuance to December. Mr. Neal has a pending application to Phoenix House, and he's got other applications out to different programs, so hopefully we can get this resolved in December.
Okay, both of them are VOP cases?
Yes, sir.
Okay, so when do you want to set it?
December 14th.
Okay. I'll see you back here no later than December 14th. If you want to enter a plea before that time, Mr. Kleins can set you up.
All right.
Okay?
All right,
Thank you, sir.
Talk to you.
Thank you. Hello, Mr. Waddell. Come on in.
Judge, this is Mr. John Richard Waddell before the court in 23 CF 1430. Sit right here. Judge, I set the day's court hearing after receiving a report prepared by Dr. Zeman that was sent to the court. Has the court had the opportunity to review that?
I have. The one where he saw Mr. Waddell on September 22nd of this year. Yes, sir.
Correct. And Judge, the recommendation in that report is that Mr. Waddell be sent to the Florida State Hospital and be deemed incompetent to proceed. So I will defer to the court at this point.
To the state, any objection?
No objection, Your Honor. We would accept that finding.
Okay, I do find Mr. Waddell incompetent to proceed. So, Mr. Waddell, they'll take you to the Florida State Hospital, and then I'll see you after you go there, okay?
Sir, is that the one by Tallahassee?
Yes.
Yes, sir.
Well, sir, I really put that minute sheet, I pleaded not guilty.
Yes, sir.
I did at Florida State Hospital, purchased Nathan Prince, but I'll accept that offer.
Okay, thank you,
And
sir.
God bless you.
Thank you. God bless you, too.
Do you have a folder for this?
I don't have an extra folder, sir. I'm
All
sorry.
right, I make monthly, I'm fully retired all the way back to 1984. Can you straighten out my canteen and my tablet, please?
The jail is going to have control over your canteen and your tablet. I'm not going to have any control.
My attorney, my accountant, and everything stopped. I'm fully retired. My blessing. That will check the drug.
Judge, may I approach with an order?
Yes, sir, thank you.
Alfred Williams will be next.
Thank you. I'm not touching.
Judge, this is Mr. Alfred Williams before the court in two cases, 23 CF 1374 and 23 CF 1375. Judge, I'd like to continue this case until the 18th of December. We are working with the state to resolve it. I need to provide Mr. Snell some additional information related to jail credit before a decision was made.
Okay, at 9 o'clock?
9 o'clock without subpoenas.
Okay. I'll see you back here no later than December 18th. Thank you, sir.
Judge, this is Mr. Derek Wilson before the court in 19 CF 1787. Judge, we have reached an agreement. Mr. Wilson's violation of probation, he's going to be admitting to the violation of probation at this time. The agreement with the state is an adjudication of guilt. Any questions? No. And the state is going with probation's recommendation here, which is reinstate his supervision to complete the original conditions, extend 1 year, and modify the remainder of that supervision to community control, and to include substance abuse evaluation, treatment, mental health evaluation, treatment, and weekly NA or AA meetings. There'd be a $100 VOP fee, a $150 cost of defense. May I approach with that agreement?
Yes, sir. Do you live?
And to probation, he lives in Fort Walton. May I approach?
Yes, sir. Thank you. Are you going to be employed?
And Judge, he will be employed upon his release, so there would be a $40 a month cost of supervision.
Thank you. Good. Mr. Wilson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Mr. Wilson, did you read the plea agreement?
I did.
Do you understand it?
I do.
Did you discuss it with your attorney?
I have.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes, very much so.
Did you sign the plea agreement?
I did.
Mr. Wilson, I do accept your plea. You're adjudicated guilty. You're sentenced. Your current supervision is reinstated but extended for an additional 1 year. All of your supervision is converted to community control. You'll need to submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. You also need to do similarly on the mental health evaluation within 30 days from today. And if any treatment's recommended for that, begin that within 60 days from today. You'll need to attend weekly NA and AA meetings, so it's both, or is it one or the other
I
per
think
week?
it would, either or would suffice.
Okay. So one or the other of that every week. You'll need to pay the $100 VOP fee, $150 public defender's fee, and continue to pay the $40 per month cost of supervision. Okay. Thank you, Mr. Wilson. Good luck to you, sir.
Thank you.
Okay. Because once you're released, you got to get the probation to check in immediately, okay? That's fine.
Hello, Ms. Watson.
Judge, this is Miss Angela Watson before the court in 23 CF 722. I would like a continuance until December 14th. There is a pending evaluation. I'm expecting to have the results of that evaluation from Dr. Zeman by that time.
Okay. Ms. Watson, I'll see you back here no later than December 14th. Thank you, ma'am.
Next, we have Tracy Rosado from the 2:30 docket. Mr. McLean said we could see her early.
Okay.
Judge, this is Miss Tracy Rosado in 23 CF 457. This was set on the 2:30 docket originally as a competency hearing. The latest APD doctor to evaluate Ms. Rosado is evaluating her tomorrow. So I expect there to be a pretty quick turnaround in that evaluation before we get to a contested type of a competency hearing for Ms. Rosado. I would ask for December 14th at 2:30 for that. I do expect at that time that we are primarily going to be arguing about placement for Ms. Rosado because she has been found incompetent to proceed.
Yes, sir.
I believe if we're narrowing the competency issues to what do we do from here as far as placement, whether it's conditional release or involuntary commitment, that is going to be the type of argument I would expect at the competency hearing, obviously pending the results of the evaluation from tomorrow.
I understand. Ms. Rosado, I'll see you back here on December.
I do have a question.
Yes, ma'am.
My co-defendant is here in jail. I wanted to testify against him, and I was afraid to testify against him. Now I'm feeling like I need to for my case.
Okay.
At 2:30?
Yes, ma'am. Okay, thank you. Thank you, Ms. Rosado.
That would be December 14th at 2:30?
Yes, sir.
Now we'll go back to the Robert Stansberry judge.
Thank you. Okay, thank you. Okay, Mr. Stansberry.
In order anymore.
If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Do you mind, Rachel, putting the lectern down, and if he can get closer to a microphone?
Come back here first. I don't want to screw it up. I'll try not to break, Judge.
Okay.
No. No promises. Is that good?
That's great.
Thank you.
Speak right into this microphone, okay?
So if you'll please state your full name.
Robert Danny Stansberry?
Mr. Stansberry, do you understand that you have the right to a lawyer?
Yes, Your Honor.
If you can't afford to hire an attorney, do you understand that one will be appointed for you?
Yes, Your Honor.
And actually, you're represented by counsel now.
Yes, Your Honor.
And for the record, you wish to basically fire that attorney and represent yourself, correct?
Yes, Your Honor.
Here are some of the advantages of having an attorney.
The advantages of having an attorney?
Yes, sir.
I mean, the fact that...
I'll tell you what they are,
Yes,
okay? A lawyer's legal knowledge and experience may assist you in attempting to set a bond, reducing a bond, or obtaining pretrial release. A lawyer may obtain information about the case through skillful use of discovery devices. A lawyer may discover possible violations of constitutional rights, take the proper steps to address them. A lawyer may make sure the speedy trial rule and statute of limitations are enforced. A lawyer may identify and obtain favorable evidence to introduce at trial on your behalf. A lawyer can, if appropriate, file motions to exclude evidence, to suppress evidence, and to dismiss or reduce charges against you. Do you understand those advantages?
Yes, Your Honor.
Do you still wish to represent yourself?
Yes, Your Honor.
Let me tell you some of the ways a lawyer can help you in deciding whether to enter a guilty or no contest plea. A lawyer can advise you as to whether entering a plea is in your best interest. A lawyer has the experience to help you work with the state and even bargain for different terms. A lawyer can tell you the advantages and disadvantages of what you might say to the court during your plea hearing and the sentencing hearing that will follow. Do you understand that you will not get any special consideration from the court just because you are representing yourself?
Yes, Your Honor.
Do you understand how necessary a lawyer is and how he or she could help you?
Yes, Your Honor.
What is Mr. Stansberry currently charged with?
It's a violation of probation, Judge, for underlying charges of larceny, petty theft, third subsequent conviction, possession of a controlled substance, and then possession of drug paraphernalia.
Thank you. So, Mr. Stansberry, have you received copies of those information, those charging documents against you?
Yes, Your Honor.
Okay.
Judge, I believe it's a violation of probation.
Okay. Have you received a copy of the violation of probation?
Yes, Your Honor. Yes, Your Honor.
Do you understand the seriousness of the nature of the charges against you?
Yes, Your Honor, I do.
What is the maximum sentence that Mr. Stansberry could be sentenced to?
$11?
11 years?
I think so.
Okay. So, Mr. Stansberry, do you understand you could be sentenced up to 11 years in prison or jail?
Yes, Your Honor.
You may be required to report to probation or a community control officer if the court sentences you to supervision. You may be required to pay a fine or restitution. You may have a permanent criminal record. Do you understand these possible consequences?
Yes, Your Honor.
Do you have any questions about those possible consequences?
No, Your Honor.
Let me tell you some of the ways a lawyer could help you at trial. A lawyer has the experience and knowledge of the entire process. Your lawyer will argue for your side during the whole trial and present the best legal argument for your defense. and this one's a violation of probation, so it'd be a violation of probation hearing. It'd basically be a judge trial. A lawyer can call witnesses for you, question witnesses against you, and present evidence on your behalf. A lawyer can advise you on whether you should testify, the consequences of that decision, and what you have a right not to say. Do you understand that?
Yes, Your Honor.
A lawyer has studied the rules of evidence and knows what evidence can and cannot, excuse me, and cannot come into your trial. And when I say trial, it's an evidentiary hearing, a violation of probation. A lawyer can make objections during the trial to try and keep certain testimony and evidence from being introduced at the trial. A lawyer may provide assistance in ensuring, nope, that's about a jury, we'll skip that one. A lawyer may ensure that any errors committed during the trial are properly preserved for appellate review by a higher court. Do you understand those advantages?
Yes, Your Honor.
If you are convicted, a lawyer may prepare for sentencing and make sure that favorable facts are brought to the attention of the court. A lawyer may make sure that the court is aware of all legally available favorable dispositions. A lawyer can make sure a proper pre-sentence investigation report is prepared on your behalf. A lawyer may help bring witnesses to court to testify on your behalf at sentencing. A lawyer may make sure that any sentence is lawfully imposed. An attorney's legal knowledge and experience may be useful in filing an appeal and in seeking release on bail pending the appeal. Do you understand that?
Yes, Your Honor.
As it is almost always unwise to represent yourself in court, let me tell you a few of the disadvantages of representing yourself. Do you understand that you will not get any special treatment from the court just because you are representing yourself?
Yes, Your Honor.
Do you understand that you will not be entitled to a continuance simply because you wish to represent yourself?
Yes, Your Honor.
You will also be limited to the legal resources that are available to you while you're in custody. You will not be entitled to any additional library privileges just because you are representing yourself. A lawyer would have fewer restrictions in researching your defense or investigating your case. Do you understand that?
Yes, Your Honor.
You are not required to possess the legal knowledge or skills of an attorney in order to represent yourself. However, you will be required to abide by the rules of criminal law and the rules of courtroom procedure. These laws took lawyers years to learn and abide by. If you demonstrate an unwillingness to abide by these rules, I may terminate your self-representation.
Yes,
Do you
Your Honor.
understand that?
Yes, Your Honor.
Do you understand that if you are disruptive in the courtroom, that I can terminate your self-representation and remove you from the courtroom, in which case the trial would continue without your presence?
Yes, Your Honor.
Do you understand that your access to the state attorney who is prosecuting you will be severely reduced as compared to a lawyer who could easily contact the state?
Yes, Your Honor.
Do you understand that the state will not go easier on you or give you any special treatment because you are representing yourself?
Yes, of course, Your Honor.
If you represent yourself and you are convicted, you cannot claim on appeal that your own lack of legal knowledge or skill constitutes a basis for a new trial. In other words, you cannot claim that you received ineffective assistance of counsel.
Yes, Your Honor.
Do you understand these dangers and disadvantages of representing yourself?
Yes, Your Honor.
Do you have any questions about these dangers or disadvantages?
No, Your Honor.
During the time that you were represented by counsel in this case, did you discuss this case with your attorneys?
No, sir.
Okay, you never discussed these cases with your attorney?
I've not had no contact with any attorney in the whole time I've been incarcerated leading up to today's appearance.
Okay. And knowing that, you don't want to seek for me to replace your current attorney for ineffective assistance of counsel, you just want to represent yourself?
Yes, Your Honor.
Okay. Meaning, yes, you just want to represent yourself?
Yes, Your Honor, I just want to represent myself.
Okay. Okay. Just a few questions about competency to waive. How old are you?
58, Your Honor.
Can you read?
Yes, Your Honor.
Can you write?
Yes, Your Honor.
Do you have any difficulty understanding English?
No, Your Honor.
How many years of school have you completed?
I have an associate's degree, Your Honor.
Are you currently under the influence of any drugs or alcohol?
No, Your Honor.
Have you ever been diagnosed or treated for a mental illness?
No, Your Honor.
Do you have any, well, this one's pretty evident, but your physical problems, do you think that will hinder you in representing yourself?
No, Your Honor.
Has anyone told you not to use a lawyer?
Say it one more time.
Has anyone told you not to use a lawyer?
No, no, Your Honor.
Has anyone threatened you that if you hire or keep a lawyer, that something bad will happen to you?
No, Your Honor.
Have you ever represented yourself in a trial in the past?
And not in a trial, no, Your Honor.
Having been advised of your right to counsel, the advantages of having counsel, the disadvantages and dangers of proceeding without counsel, the nature of the charges and the possible consequences in the event of a conviction, are you certain that you do not want me to, well, that you don't want to continue to be represented by appointed counsel?
No, I'm fine, Your Honor. Thank you.
Do you wish for me to appoint the public defender to represent you as standby counsel? What that would mean is, as we keep going through this process, if you ever raise a white flag and say, okay, I need an attorney, the public defender would then be able to stand in and help you. They wouldn't be there to do legal research and help you in the interim, but they would follow your case and then be able to step in if you don't want to represent yourself anymore.
Actually, that'd be a good idea, Your Honor.
Okay, so I do appoint the public defender to represent Mr. Stansberry as standby counsel only, and Mr. Stansberry, you represent yourself. Okay?
Thank you, Your Honor.
So what do you want the court to know?
I was given probation the last time I was in court. I accepted probation on the terms of I had a burglary that had been thrown out due to a statute of limitations. I accepted the probation on agreement to still pay the restitution on said charge. I was released from jail. The very next day, I reported to probation, done everything I was supposed to do, and the very next day after that, I had a massive heat stroke with kidney and liver failure and went in the hospital, stayed in the hospital, so I did not willfully violate.
It's kind of like, you're familiar with Robert's Rules of Order? You know, as far as meetings, I need to know exactly where we stand. So if you want a violation of probation hearing, which is like a judge trial for me to determine if you violated probation, then I need to set that. I need to give the state notice where they can call any witnesses that they want. So that appears to be what you're asking for. Is that right?
I would actually like to see if the state has an offer today.
Okay, good. Does the state have an offer?
You know, for expedience.
Good.
As far as today, the VOP is on the docket, is 22 CF 1999. I believe there's another case that's not included in this VOP that needs to be.
Okay, what is that?
But right now, it'd be a guideline offer somewhere around 24.75 months DOC would be the offer at this time, but I'm not prepared to make that until I make sure I have both case numbers on the VOP.
Okay, but it'd be over 20 months in prison.
Yes, sir.
So, Mr. Stansberry, that's the offer from the state to you.
May I ask to say the question?
Sure.
Your Honor, I'm sorry. Since I did not willfully violate, and there is a question of the restitution, I have been in contact with the VA representative. I'm still willing to make the restitution. All I'm asking is some community control to show that I did not willfully violate. I'm asking for a second chance. I have VA representatives. I have a BOS officer in Shalimar. I will stay in contact daily with my probation officer.
Those people that you want to talk to me, you need to get them in touch with me.
Would you agree to a 12-1 today?
Not today.
16 months?
Not today.
Okay, so we want to set it for an evidentiary hearing with subpoenas, meaning ready for a judge trial? Okay.
Again, I've got to add that case number to it, but I'll do that right away.
Okay. What do we look like on December 18th? At 1:30.
I have a lot of medical issues. I need to move on with my life.
You only have 2 things set.
Okay.
Because the VA representative has me a place to live, my surgery schedule, give me the guideline, credit for time served, terminated probation.
Perhaps if we came back later on today.
Bring him back at 1:30.
Okay, you want to keep
1:30.
Mr. Stansberry and bring him back at
Go and
2:30?
Get the other case and make sure I have the right numbers.
Okay, so Mr. Stansberry, I'll see you back here this afternoon, okay?
Yes, Your Honor.
Good, thank you. What else for this morning? As everybody stretches.
This afternoon, I have Rebecca Martin, and I had emailed the court yesterday. I just didn't want to presume that the court was going to continue. That's why I worded that.
Is that on 2:30?
2:30. But I was just going to ask the court to continue Ms. Martin's sentencing to December 14th.
Any objection from the state?
No objection, Your Honor. We're already reached out to drug court.
Good.
She's going to be getting evaluated by the treatment team. That generally takes about 14 days. And then if she gets approved by then, hopefully we'll have her into drug court within 2 weeks. She'll fall off the docket if we think she's an appropriate candidate.
Okay, so Ms. Martin's case is continued,
December 14th would be a good date.
and it's 18 CF 2141. How far out? 18th?
December 14th.
December
good.
14th at 9 o'clock. Okay.
Thank you.
Do you want to address the Rubia? The Rubia.
Oh, yeah. With Mr. LaRubia, Your Honor, in reviewing the state's response and reviewing some body camera footage, the defense will go ahead and withdraw the C4 motion from Mr. LaRubia.
Okay.